Aloha mai kako and good morning. This is the May 25th, 2022 Land Use Commission meeting. It is a hybrid meeting, which is being held at the Honolulu Airport Conference Center, where it is open to the public, and also by interactive technology, which links video conference participants and other interested individuals of the public via the Zoom webinar platform in order to comply with state law. Members of the public are able to attend in person or view the meeting via the Zoom webinar platform. For all meeting participants, and this works for both virtual and in person, I'd like to stress for you the importance of speaking slowly, clearly, and directly into your microphone. It is helpful because we do the transcripts from this hearing from the Zoom recording. If you identify yourself prior to speaking, please be also aware that if you are participating in this meeting via Zoom, all meeting participants are being recorded, and your continued participation is your implied consent to be part of the public record of this event. This technology, as we know, allows the parties and individual participating commissioners individual remote access to the meeting via our own digital devices. Due to matters outside of our individual control, occasional disruptions to connectivity may occur from time to time. If this happens, please be patient and let us know as we try to restore audiovisual signals. I would much prefer to be physically in person with all of you today, but I am recovering from COVID. I got caught in this current wave, and while I am now out of isolation, it's the last day in which I would have to wear a mask all the time while indoors, which would make chairing the meeting more difficult. We will take breaks from time to time. Approximately 10 minutes every hour. My name is, sorry, I'm just going to check. Is my audio not coming through well?
It's soft.
No, it's coming through okay.
Kind of soft.
Okay, so is there a way to increase the volume at the airport?
Jonathan might be louder on his phone, have his Zoom for his picture. And I did that in a lot of my meetings,
Okay.
and their phones come through. And
How's the audio now?
Better.
Okay, I'll do my best to project. Thank you for that. So my name is Jonathan Lee K.K. Scheuer. I currently have the honor and pleasure of serving as the Land Use Commission Chair. We have 9 seated commissioners: Commissioner Nancy Cabral, Don Chang, Commissioner Kamakea Ohelo, Commissioner Giovanni, Commissioner Ohigashi, Commissioner Okuda, and Commissioner Wong are all at the Airport Conference Center, along with our staff, Scott Derrickson, our chief, who's our chief planner, our staff planner, Riley Hakoda, our staff planner, Martina Segura, and our chief clerk, Natasha Quinones. Also participating remotely along with me from the island of Oahu are our executive officer, Daniel Ordenker, and our deputy AD du jour, Dan Morris. As I said earlier, court recordings are being done from this Zoom recording, court transcriptions. Commissioner Axon is excused from today's meeting. With all of that said, our first order of business is the adoption of the May 19th, 2022 minutes. Ms. Quinones, the minutes for the last meeting are not ready. Is that correct?
Good morning, Chair. That is correct. The minutes are not ready for this, for May 19th.
Okay. Then we'll move on to our next agenda item, our tentative meeting schedule. Mr. Ordenker.
Thank you, Mr. Chair. On June 23rd, we will be, if necessary, taking up a continuation of this matter, and an adoption of order if necessary. On July 27th and 28th, we will be having an orientation for new commissioners. This is not going to be to take up any petitions. This is just an effort to educate the new commissioners on land use commission procedures and policy. August 25th is our next confirmed date to take up the City and County of Honolulu stormwater issue. And then that leaves us open until HCPO. However, we would once again caution the commissioners, we know that there are a couple of special use permits and 201H projects that are presently in the works at the county, and they could be submitted at any time. So we would caution the commissioners not to release those dates until such time as we get confirmation on those. Thank you.
Thank you, Dan. Commissioners, are there any questions for Mr. Ordenker regarding our schedule? Seeing none. Our next agenda item, our main agenda item, is a continued action for docket number A87610, Kamehameha Schools, WAIAWA, Oahu, to consider the petitioner's motion for modification, time extension, and release and modification of the conditions of an order, granting a motion for an order, amending the findings of fact, conclusions in law, and decision and order issued by the commission on February 11th, 2020, to allow for modification of the phase 1 and phase 2 of the solar farm, and to modify and release various conditions under the commission's 2014 and 2020 decisions and orders concerning requirements of the submission of a master plan, archaeological sites and plans, burial plans, historic resources, aircraft hazards, traffic, development plans and schedules, and decommissioning of the solar farm phases. Will the parties please identify yourselves for the record, starting with the petitioner?
Good morning, Chair and members of the Commission. This is Jennifer Lim, representing petitioner Kamehameha Schools.
Good morning, Chair, members of the Commission, Onaona Thone on behalf of petitioner Kamehameha Schools. With me today is Derek Simon. Thank you.
County.
Good morning, Mr. Chair, members of the Commission. Dwayne Pang, Deputy Corporation Counsel on behalf of Department of Planning and Permitting.
OPSD.
Good morning, Deputy Attorney General Brian, on behalf of the Office of Planning and Sustainable Development. With me is Lorene Maki from OPSD.
Thank you very much. Now let me update the record. On April 12th, 2022. Yes.
Chair, this is Commissioner Kamakeo. Hello. In all transparency, I have something to disclose at this moment.
Okay. I have space for disclosures later, but I'm more than happy to do them right now, if you wish, Commissioner.
Yes, Chair. As early as 2 weeks ago, I met with the Director of Community and Aina Resiliency, as well as the Director of Sustainable Industries for Kamehameha Schools, with the interest of leasing the 1,800 acres for agricultural purposes, just mark of the parcel that is in discussion today. That is all.
Thank you for your disclosure, Commissioner. You were participating in this as seeking personally to lease this parcel?
Correct. Yes, for farming.
Okay.
I just, at this moment, I just wanted to make it clear that I met with Kamehameha Schools with interest of farming in the WAIAWA Ahupua'a.
I thank you very much, Commissioner. So the normal standard that we have, I'll ask for any clarifications from Mr. Morris and Mr. Ordenker, is that one should not participate in a docket where there's a potential of them having an individual commissioner having a personal financial benefit from this. Normally, if that's the case, the commissioner recuses from the matter entirely. If there's not, or the commissioner does not believe that there's a personal financial benefit to him or his immediate family member, then that individual would declare that they believe that there's no direct financial benefit, that they believe they can be fair and impartial in this matter. And then I would ask the parties to see whether or not there is an objection to the commissioner's continued participation. So let me first check with Mr. Morris and Mr. Ordenker. Have I stated our rules of participation correctly? Mr. Morris, then Mr. Ordenker.
Yes, that's correct. Mr. Chair.
Yes, Chair Schroyer, although I will point out that the decision whether to recuse is from his individual perspective as opposed to my representation of the LUC as a body.
Yes, thank you very much for that. So having said that, is the nature of the relationship that you're disclosing, Commissioner, one in which you would personally financially, you or your family would, immediate family would personally financially benefit from the decision that we are to make today?
Yeah, very clearly, the answer is no.
Okay. With that said, do you feel that you can remain fair and impartial in participation in these proceedings today?
Yes.
Okay. I will now offer the opportunity for any of the parties to object to your continued participation. If they do, then we will take that into deliberation, starting with the petitioner.
Thank you, Chair. Thank you, Commissioner. May I just ask a question for clarification?
Please.
When you indicated a discussion about leasing, that this is news to me, but I just want clarification. The 1,800 acres, that's not within the urban district land that's before the commission today. Is that correct?
Yes, that's correct.
Okay. Then after conferring with my client as well via text, we don't have any objection whatsoever to his participation. Thank you.
Sydney County of Honolulu, DPP.
Thank you, Dwayne Pang. Based on the last response by the commissioner, we have no objections.
Okay, thank you. OPSD, Mr. Yee.
OPSD would have no objections, although we think it may be prudent to also represent that any decision reached in the case today or in this matter, you do not reasonably believe will affect your negotiations as to your ability to receive a lease for the 1,800 acres.
Commissioner, did you understand the assurance that Mr. Yee was seeking you to make?
Yes.
And do you make it?
The short answer is yes.
Okay. Anything further, Mr. Yee?
Nothing further, thank you.
Okay, thank you very much. Thank you for that disclosure. Are there any, just to jump to that portion of this proceedings, do the commissioners have any further disclosures to make at this time? Okay. Going back, on April 12th, to update the record, DPP filed its notice of appearance of counsel for Brianna Weaver. On May 2nd, petitioner filed a supplemental memorandum in support of its December 10th, 2021 motion, its third list of exhibits, a declaration of Derek Simon, a certificate of service, and exhibits 48 through 57. On May 16th, the LUC mailed and emailed the agenda for the May 25th, 2022 meeting to the parties and the statewide and county mailing lists. On May 17th, the county filed its proposed revisions to conditions 10 and 11. And on May 24th, the petitioner filed a second stipulated proposed conditions of approval. Having now updated the record, let me go over the procedures for today. We've already dealt with disclosures. I will then recognize any written testimony that has been submitted in this matter, identifying the individual organization. We have concluded oral testimony on this matter from the general public. So following noting any written testimony, where we left off was that on April 14th, OPSD had both presented some of its oral argument and then also asked for the opportunity to brief the commissioners on issues raised during the questioning of the parties. So I will begin our proceedings today with OPSD continuing its presentation, followed by parties and commissioners' comments and questions for the OPSD. Following OPSD's presentation and questions thereon, the commission will consider any new exhibits that any of the parties are wishing to offer into evidence. Following that, the petitioner will be given the opportunity to provide any rebuttal or closing arguments. with questions from the parties. And then finally, after all parties have presented closing arguments, the commission will conduct formal deliberations and hopefully issue a decision on the motion. As I noted before, from time to time, approximately 10 minutes every hour, we will take a break as well as a longer break for lunch. Are there any questions with our procedures for today, starting with Ms. Lim?
Chair, no questions, but just to remind the commissioners, pursuant to a request from last hearing, we do have Ms. Sato and certain other witnesses available if there are questions from the commissioners directed to them. Thanks.
Thank you very much, Ms. Lim, for that reminder. That's very helpful. Clarity on our procedures, Mr. Pang?
No questions, Mr. Chair.
Okay, Mr. Yi?
No questions. Thank you.
Okay, thank you very much.
Chair.
Yes, Commissioner Giovanni, Vice Chair Giovanni.
Yeah. First, a question. Is there any hard stop on today's hearing?
Commissioners, do you have any details on the hard stop?
Chair, this is Commissioner Wong.
Mm-hmm.
I need to leave by 3 o'clock if possible.
Okay.
Thank you. Secondly, Ms. Lim, you just mentioned you have some of your evidence witnesses available. Does that include the developers of the wind farm?
Commissioner Giovanni, we have Mr. Nick Molinari. He is available via Zoom. He's on the mainland today. And then we have the chaos witnesses and also the various technical consultants. So to answer your question, yes, but he's going to be participating remotely if there are questions.
Yeah, I have a couple questions for him. Thanks.
Okay, thank you. Any other questions about our procedures today, commissioners? Seeing none, Ms. Quinones, has there been any further written testimony submitted on this docket?
No, Chair, no testimony has been received on the docket
Since our last hearing?
since April 14th.
Okay. So we will now continue with the presentation from Mr. Yi.
Thank you, commissioners. I think in light of the presentation provided at the last meeting, I think we're satisfied with the presentation we made, and we will rest on it. If there are any questions about this or other matters, of course, we'd be happy to answer them. I think it'd probably be best at this time to simply rest and address any questions which the commissioners may have.
Sorry, Mr. Yi, so you're just available for questions?
Yes.
Okay. Commissioners, or sorry, parties. Starting with the petitioner. Questions for Mr. Yim?
I'm sorry.
No? Sorry.
Normally, this is not I'm happy to answer questions, but normally we don't subject the arguments to cross-examination.
You were correct, Mr. Yim. Sorry. Commissioners, questions?
Chair, this is Gary Okuda, if I may.
Please, Commissioner.
Mr. Yi, did you review the petitioner's filing, which was a supplemental memorandum, which was filed May 2, 2022?
I did.
Do you have any comment, either in support or against, or no position with respect to what the petitioner filed in its supplemental filing?
I think OPSD is not prepared to support the ultimate conclusion, but we also think it is it is frankly premature, as this matter has not, order show cause has not been filed. And we also think it's premature because we believe this will probably be a much bigger issue when the district boundary amendment and the motion to amend is filed. So this may all go away and become moot if the Land Use Commission, for example, imposes a condition after the motion to amend to substantially comply with the representations and to substantially commence within a certain time period. So we think it is unnecessary to address the issue today on this motion, but certainly feel it will be a much more important issue to be raised later.
Let me ask just a couple follow-up questions related to the supplemental memorandum filed by the petition. The first question, and maybe both questions, go to the issue of whether or not there's a risk or no risk that public notice requirements or sunshine requirements have been met. First of all, do you believe that there is sufficient, or let me rephrase that and withdraw the question. Do you believe that there is a risk that there's potentially insufficient notice given if the commission intends to have a deliberation or discussion about anything to do with reversion?
It's certainly not on your agenda. And so I think any discussion toward deciding some issue regarding reversion would not be consistent with sunshine law. I'm not sure if I answered your question, but that's...
Yeah, okay. And based on your answer, I have no further questions. Thank you, Mr. Chair.
Thank you, Commissioner Okuda. Commissioners, Commissioner Chang.
Sorry, Commissioner Giovanni had his hand raised up.
Okay, so I apologize. The way the camera is, I cannot see Commissioner Giovanni. So all I could see was that you were reaching for your microphone button. I apologize. Commissioner Giovanni, followed by Commissioner Chang.
Thank you, Chair. This is Commissioner Giovanni. In that filing that was just referenced by Commissioner Okuda, there's a condition number 9 that's restated, which is, if you recall, petitioner shall complete construction of the backbone infrastructure for proposed WAIAWA master plan phase A, consisting of primary roadways, access points, internal roadways, on and off site water, and electrical system improvements and stormwater drainage and other utility system improvements by December 31st, 2030. You remember that condition that was placed on the phase 2 solar project?
I do.
It's my recollection that that condition was actually originally put forth by OPSD. And at our meeting, our hearing on April 14th, the petitioner acknowledged that they would be amenable to a similar condition on phase B, should we approve the solar phase 1. Would the OPSD support such a condition?
We would, with the understanding that all of these conditions and the dates set are subject to review and reconsideration on the motion to amend and the DBA. And if I may explain, one of the reasons OP didn't push for some of these dates, et cetera, is we think we will have a better idea of the appropriate dates to set. If we were to set it now, OPSD was concerned we would be forced to be conservative and cautious in setting a date too soon. But we would have a better set of information to set a more appropriate date closer to construction. So in other words, when they come back again for a DBA, we would expect a somewhat more rigorous review as well as analysis by the petitioner on the dates that they have set. Right now, they're really creating, you've heard the cross-examination I made of their Gantt chart and the dates. The charts are fine. I think they could be tightened, quite frankly. I think for our purposes of whether or not to move forward with the motion today. They are fine. When we get to the district boundary amendment procedure and the motion to amend, we may analyze it more closely, and they may have a more rigorous analysis close as we arrive there more closely. So we think we could probably get a better date, more better certainty as to what's the appropriate date. So while we conceptually have no problem with the imposition of a date now for phase B, we certainly want to leave open the possibility of revisiting this when we have better information later. So I'm sorry, that's a long explanation to your answer.
No, I understand, but conceptually, if we include such a condition for phase B and a date, that date could be reviewed at time of this commission takes under consideration a DBA for the property, and revise those dates, correct?
Then we'd have no objection.
Thank you.
Thank you, Commissioner Giovanni. Commissioner Chang.
Thank you, Mr. Chair. Mr. Yee, at the last hearing, we did ask the question regarding substantial commencement. If it's not in the, as argued by the petitioner, if it's not a condition in the order, then it isn't, then the commission has no power to revert the property for substantial failure to substantially commence. And that is their argument. And I guess what I heard you say today is that you think it's premature and moot, or you think it's premature at this time to raise the question. But if the commission acts on the motion to amend, which permits the development, although it's an interim solar farm, wouldn't that then, isn't that why the question is ripe? Because we have a situation where there will be use, even if it's interim and temporary. So I'd like to hear what your opinion, because it's not only this particular case before us, but Office of Planning's position when the condition is not in the original order.
There are multiple responses. So if you'll permit me. One, the Office of Planning is certainly not prepared to admit that the LUC has no authority to revert if there is a violation of a condition. If there's a violation of a condition, Office of Planning certainly wants to reserve the right to argue that the property can be reverted. So we're not prepared to admit and agree. Two, we don't think it should affect, two, we think this issue will be resolved on the motion to amend in the DBA. So we think it will go away because we think this is going to be dealt with later. So we don't have to engage in the analysis that petitioner has brought. Three, I understand the argument of, but the LUC has to decide today whether or not to allow the solar farm to move forward. And so shouldn't we address this question now? I think our response is twofold. A, we believe there is a very strong likelihood that the motion to amend in the DBA is going to happen because it is such an enormous piece of property that would be affected by the inability to amend the conditions. That the solar farm in and of itself is not going to be a barrier to them moving forward on this. And B, we think the solar farm is a good thing. we should let them move forward with this. And so we don't think, because we think the risk is low, that this issue, that the solar farm, because we think the risk is low that this issue is somehow going to escape LUC review. In other words, there's a strong likelihood it will come back to you on the DBA. And because we think it's a good project to move forward, we don't think this question of substantial commencement should affect your decision on granting this amendment to allow the solar farm to move forward. It's an issue of risk and judgment, admittedly, but it's also combined with, this is not a simple question. This is not one in which, I can guarantee a result. So, sort of taking all of those factors together, OPSD believes it's really just better to be willing to grant the motion today and then to address the question in which you would have absolute authority, right? Because you could always just deny the motion to amend if you're unhappy with their willingness to substantially comply with the representations and to commence or complete within a certain amount of time. And in which case the entire parcel will be effectively unworkable, because I would be hard pressed for me to imagine that they can develop this based upon the prior representations and prior uses that were made. So for those reasons, those are the reasons that we thought it would be best not to consider the question, not to decide the question today, and instead to correct the motion and address it on a later date.
Okay, I guess, Mr. Yee, I understand your position. I find it somewhat unsatisfactory because, one, I guess I'm not looking at the merits of the project or what they're proposing. It is just the time period and how we have treated other projects similarly situated where they have not substantially commenced work and we have actually taken action to revert. And they've raised meritorious projects as well. But in my view, your OPSD's opinion or their rationale, assuming that we grant the motion to amend, which would permit the solar use, I think it takes away the ability for the Land Use Commission to make that argument on the DBA or on a motion to amend during the DBA, because they will argue that they've already commenced. They've actually started using the property. So I understand the position. Again, find it a little less, especially coming from Office of Planning. Because this may be a recurring issue that comes up. So I would have hoped to have gotten guidance from OPSD, but that's fine. No other questions. Thank you.
If I could just add, if this issue comes up, if you have another case, let's put this one to the side, in which there is no requirement to substantially commence, to revert unless you substantially commence, the Office of Planning will have a position, and we will look for a way that reaches the best equitable solution and the best argument to reach that equitable solution to ensure that the conditions of the LUC are complied with. We just don't think this is the case to deal with. Let's deal with it.
Thank you.
Chair.
Thank you, Commissioner Chang. Commissioner Okuda.
Thank you very much, Mr. Chair. This is Gary Okuda. Mr. Yee, following up on Commissioner Chang's question, can you point to any legal authority that indicates or shows that if the solar project commences construction, that would not be considered substantial commencement as the term is used in the Bridge Ainalea case? And just to put it in layman's term, for people who aren't bored like you and I are to read these cases, bottom line is the only real enforcement power the Land Use Commission has is reversion. And if there's substantial commencement of use of the property in accordance with the representations, we lose that ability. So my narrow question is a legal question. What legal authority can you point to, citation of either statute or case, which indicates that the use of the property for the solar farm would not be considered substantial commencement, which would thereby negate the ability of the Land Use Commission to do reversion, as those terms are defined in the Ainalea case?
So if the issue came up hypothetically, I think an argument can be made that given the size of the property, the enormous amount of money that would have to be spent.
Yeah, I don't mean to interrupt you, but I'm not looking for the argument. I'm looking for the citation to legal authority, or do you agree that there really is no legal authority one way or the other to answer that question?
The only legal case I'm aware of is Bridge Ainalea, which looked at a monetary amount, which frankly, I think we should ask the Supreme Court to reconsider whether a base monetary amount is a sufficient basis, and rather it should have been a percentage of the total monetary amount required. But that's the only case that I'm aware of that addressed whether or not something has or has not substantially commenced. If I might mention to you, the argument from the petitioner, as far as I can tell, is not that they have or have not substantially commenced. It's that there is no condition.
Mr. Yee, I don't mean to cut you off because mine was just a simple, narrow question. What's the legal authority? Okay, my second question is hopefully similarly simple and narrow. What evidence is there in the record that indicates the better use of this property should be something other than urban?
I don't know that I could cite to you something in the record that says this property is better used as urban. We would have to address that in a subsequent.
Okay, I just want to make sure there isn't something that indicates in the record that a designation other than urban would be a better designation, so that I just want to make sure I'm not clearly erroneous in my vote for purposes of appeal, if I were to, see the fact that way. Thank you, Mr. Yee. Thank you, Mr. Chair. No further questions.
Thank you, Commissioner Okuda. Commissioners, are there further questions for Mr. Yee? I cannot see hands, so verbal would help. Further questions for Mr. Yee at this time? Sorry, was that somebody?
I said, it's Commissioner Giovanni. I see no hands raised.
Oh,
And
okay.
nobody.
Thank you. I have a quick question for Mr. Yee. Mr. Yee, if I recall correctly in your presentation to us on April 14th, one of the matters that you pointed out to us that there was no condition in the original docket that required the petitioner to stand by any representations made. Am I recalling that correctly?
That's correct.
Okay. Do they have to, does that lack of that condition carry forward to now so they can say anything to us now and we can't hold them to their representations?
I'm sorry, I think I might have misstated. I there is a position on the representation made regarding this, regarding the solar farm. There's not one regarding the original DPA. So I think representations made today about the solar farm are enforceable.
But only representations made about the solar farm.
Well, representations made in furtherance of the motion for the solar farm.
Okay. That actually still gets to, not what I expected you to say, but still gets to where I'm wanting to go. We have dealt with a large number of dockets in front of this commission, sometimes when you were with us, sometimes not, for solar farms. Not all of those have panned out. Even ones where folks came up to us and they said, you know, you have to rush this. You absolutely need to do this now. If you don't give us this, we're not going to meet our state sustainability goals. And then the solar farms, for whatever reason, internal reasons, global supply chains are not panning out. And I have to say, it's sort of like the dates you go on where you don't even get a call afterward that it wasn't a good date. You just never hear from them again. It's like Mahi Solar, I read about it in the paper, didn't hear about it from them. What's the standard that this commission should use in terms of assessing the credibility of the representations of these solar developers? Because we always say, yeah, solar is a great thing, but then we say it to everybody and a whole bunch of them aren't built.
That's a difficult question. It's true of both solar as well as sort of every development before you. There is technically for DBAs a requirement to demonstrate financial capacity. There's a general thought that a party wouldn't go through the effort of getting all of these approvals if there wasn't money to be made. But you're right. Solar farms in particular have come to the LUC, got an approval, and then were never built for a variety of reasons.
So given our duties, right, our kuleana, other than just like, well, I'm trusting this date's going to go better than the last, what are the tools or options available to this commission, particularly when, as has come up in the earlier questions from my fellow commissioners, there's questions about the relationship between this project and the overall project?
They're limited. Conditions imposed, need to be reasonably related to the impacts and have a nexus to between the condition itself and the impact. You can basically do things to limit, I guess, to say you have to build within a certain period of time is one thing we do. So if you don't, then you're back to square one. In terms of requiring development, it's a frustration. I just don't know if there's much you can do.
Thank you, Mr. Yi. I have nothing further. Commissioners, anything further? Commissioner Chang.
Sorry, may I always have one last comment? Mr. Yi, I want to give you the benefit of the doubt in your responses to me. And I'm not asking for a response at this time. But the second stipulated proposed conditions, that was circulated, and I'm hoping you got a chance to look at that. But I'd like you to think about what would be an appropriate condition to place if we were to accept and approve this. What would be an appropriate condition that would protect the Land Use Commission? Because as you say that, this is premature, wait till it comes to the DBA, the motion to amend, because this is just a very small portion of the larger project. So I'd like you to think about what would be an appropriate condition to, one, permit the solar projects to move forward, but at the same time, preserve the Land Use Commission's ability to argue, or at least to raise the issue of substantial commencement for the rest of the project, the rest of the property. So I'd like you to think about that. I want to challenge you on that because I think my responses were maybe a little I rushed too quickly. So I want to be constructive because you seem to, OPSD seems to take the position that we can do both. We can still let them proceed with the solar, but yet it's the Land Use Commission, OPSD may not necessarily agree with the arguments by the petitioner regarding substantial commencement. So if you can, when that comes up, I'd like to hear from OPSD a proposed condition that you'd recommend. Right?
If I may, I think this is going to be my only opportunity to address you.
Okay.
So may I only suggest that OPSD might have an opportunity to submit maybe not a condition, but language for the order, which preserves LUC's rights, or which perhaps simply determines that the issue of substantial commencement is not determined, and nothing in this case limits LUC's ability to make that determination at a later date.
All right. Thank you very much, Mr. Yee. I have no other questions, Mr. Chair.
Thank you very much, Commissioner Chang. Anything further, commissioners? Seeing none, we're close enough to a break time. So it is 9:47 a.m. We will resume at 10 a.m. with the admission of additional information into evidence and questioning of the parties regarding that information. We will break for 13 minutes, reconvening at 10 a.m. Can we restart the recording? I believe the recording is restarted. It's 10 a.m. We are back on the record. We're now going to move on to the admission of new evidence into the record. Ms. Lim, you have additional evidence you wish to enter into the record?
The exhibits that were previously mentioned, which are exhibits.
Oh, I cannot hear you.
7, as well as, yesterday we filed that 3-party. Can you not hear me? I feel like my voice is booming in here. Can you not hear me, Chair?
One more time. There we go.
So to repeat, the additional exhibits that we filed on May 2nd, which are exhibits 48 through 57, as well as the 3-party stipulation that was filed yesterday. That's 3 parties, KS, OPSD, and DPP. It's an amended stipulation. It amends the stipulation that was previously filed with Exhibit 40 and fully replaces that with this new 3-party stipulation. And just this morning, in the interest of trying to provide clarity for commissioners, if there were questions, my co-counsel submitted a red line demonstrating the changes that were made from that original stipulation, which was only a 2-party stipulation, to the new stipulation, which is now a 3-party stipulation. And that's the extent of the additional evidence, as well as, of course, the supplemental memorandum we filed.
Thank you. Ms. Lim, does that final document, the red line, have an exhibit number?
We did not put an exhibit stamp on it, but that would bring it to Exhibit 58.
Okay. Are there any objections from the parties for these matters to be admitted into the record, County?
The county has no objections. Thank you, Mr. Chair.
OPSD.
No objection. Thank you.
Commissioners, objections or questions? Commissioner Wong.
Sure. Just only one thing. It's not about, it's about the exhibit. Why is it marked as Raleigh, North Carolina?
I'm sorry, could you repeat that?
So in the signature line. Oh,
I'm in Raleigh, North Carolina.
okay, that's why. I just was wondering why it says Raleigh, North Carolina. That's all, Chair. Thank you.
Thank you. Any other concerns? Hearing none, petitioner's exhibits as enumerated by Ms. Lim are entered into the record. County, Mr. Pang, do you have any additional evidence you wish admitted?
The DPP has no further additional evidence. Thank you, Mr. Chair.
Okay. Just your one filing that I already noted when I went over updating the record. OPSD.
We have nothing further. Thank you.
Okay. So we've admitted all other things into the record. Ms. Lim, before we move on to final arguments, do you want to provide any further summary about the additional evidence that you've submitted?
Well, I'd be happy to do so. I would also weave it into closing comments, but let me take this opportunity. So the first, let's say from exhibit 48 and 49, those are the original WAIAWA orders. That's what the commission issued when they originally reclassified this land in 1988. Then there was an amendment in 1990, and those are relevant because of the absence of certain conditions that we've spoken about earlier, most specifically development timeframe conditions, use it or lose it, substantial commencement kind of condition, and even no requirement for compliance with substantial representations. Exhibit 50, 51, and 52 are legislative history. I trust this commission is pretty familiar with its powers of reversion and how that was granted to the commission in 1990. But in 1972, from as early as 1972, the commission did have the authority to impose a condition requiring compliance with substantial representations. However, it wasn't until 1990 that the commission was actually delegated power to revert land due to a failure to substantially commence. Of course, the commission would have always had the power to actually pursue a boundary amendment, but that's a different kind of procedure than doing a reversion. The excerpts from the city and county's Central Oahu Sustainable Communities Plan material that you've heard about, both from Ms. Ketley, one of our consultants or consultant for the solar farm developer, but you also heard from Ms. Wong and her counsel, Ms. Weaver, before. This land has long been and continues to be identified, and by this land I mean the petition area, the 1,395 acres, identified for urban uses. And in fact, under the most recent version that the city council passed just last year by ordinance, the Central Oahu Sustainable Communities Plan not only identifies this land for the urban uses, but also identifies it for the 2 solar uses that this commission already approved in 2014. Exhibit 54, again, it speaks for itself, but to perhaps reflect on some of the confusion that still seems to maybe be in the air. The solar farm, the phase 2 solar farm is substantially complete. Those photographs were provided because there were questions about substantial completion or substantial commencement. That project is essentially done. They're well on target to hit their commercial operations date under their agreement with HECO. And then exhibits 56, 57, 58, 55, 56, and 57 are all related to EIS issues. And this was directly, when I'm talking about exhibit 55 and 56, some of you commissioners raised excellent questions at our last meeting. And I know you've had a lot of meetings between our last meeting and today, but just to refresh you, there were questions about, gosh, I hope you understand at this point that we're not even ready to do the EIS. The EIS has yet to come forward. but that is in the works. And when we do an EIS, some commissioners were saying, well, wait, this is an awfully big project. How is it going to be covered in one EIS? And is there a risk that that EIS may go stale? And those are great questions. Other commissioners said, yeah, but you can't just do a little bite-sized EIS. That's segmentation. That's against the law. You've got to do what and disclose as best you can right up front at the earliest practicable time. Our intention in filing exhibits 55 and 56 were to alleviate some of those concerns that commissioners expressed. Those are the new EIS rules, EA rules, Chapter 343 rules. So not everybody's as familiar with those as we all were with the old rules. Those rules actually contemplate something called a programmatic EIS. So the idea is, okay, there are going to be some big projects. There are going to be projects that take years. There's going to be projects that, there's new components coming up all the time. The entire project can be looked at in a programmatic or program EIS with the understanding that if and when required, there can be subsequent environmental reviews that maybe don't have to look at the entirety of the project to the same level that was analyzed initially, I didn't phrase that very well. As a project progresses over time, in an EIS, you can present what you know and you can project a certain time forward. Sometimes the circumstances change, traffic changes. What happened at Turtle Bay? Monk seals came up on the beach, right? So there's an opportunity to do a further EIS review where you look at now the more specific component of the project that you're going to build and what are the impacts from that and how has that been changed from what's going on in the surrounding environment. So it's a long description, but you can see that the Environmental Council and the public was quite involved as well. And I looked at my co-counsel, Ms. Thone, because of course, as the chair of the Environmental Council, she's extremely familiar on this. There's a need for just the kind of EIS rule that you guys were articulating without expressly articulating it. So that was our interest in filing those materials to demonstrate that there is such a tool, and it's very likely that that's the kind of EIS that would be done here. And then finally, Exhibit 57 was to address some questions that came out through the discussion about the 4-year timeframe that Kamehameha Schools has on its Gantt chart. Now, we know that Gantt chart is, at this point, best guess. What do we know? We know that we have your infrastructure deadline, and we know KS wants to get moving on developing this master plan. But that Gantt chart is still a best guess scenario because the additional work has to be done, including primarily as a first step, that EIS. And EISs can take a couple of years. They can take several years. And so we filed Exhibit 57 just to demonstrate that having a 4-year time frame, and that's from the start, which is KS has already started, to actually completing an EIS within 4 years is not out of the bounds of what we've seen from EISs and even in fact some EAs over the last few years. So I'll stop there on the exhibits. The stipulated conditions, I'll just mention quickly, when DPP sent its letter raising questions about that EIS condition, the language that we had stipulated to with OP back in February, I was a little surprised because we had discussed it. Ms. Weaver and I had discussed it, and I understood that DPP had understood that KS's intent was never to try to avoid environmental review. Our intent was simply to say this condition alone won't require environmental review. And that's because environmental review is like the air you breathe. It's the law. You've got to comply with it with or without a condition. So why should we start putting in conditions that could perhaps create an ambiguity and say, well, the condition, there's no trigger. There's no reason to do an environmental review, but look, this condition says you have to, so you better do it. You see, that creates a problem. That actually creates a legal problem under Chapter 343. However, as I spoke more with Ms. Weaver and we looked at the letter that she submitted to you earlier this month, it gave us, when I say us, I mean Kamehameha Schools, an opportunity to revisit the language that we were trying to tweak to make fit into present circumstances. And you know why that is? Because you folks issued that condition in 2014. When you approved the 2 solar farms, the one that's already built and the one that AES really wants to hurry up and start building, you know, if you approve this motion, when you folks issued that order in 2014, you had a condition that said you can't do anything but solar and nothing but solar, and only in these 2 places. And before you do anything but solar, you've got to come back to the Land Use Commission with a motion to amend. And that motion to amend has to have an environmental impact statement and various related studies. So in 2014, that condition made a lot of sense. Come along to 2020, when you folks issued an order that we did not appeal, as you know, and as Mr. Yee raised, you issued an order requiring construction of the master plan. And that was a little disturbing because the master plan evidence really wasn't before you. I mean, it is a contested case hearing, and your rulings as well as your conditions have to be based on substantial evidence. I mean, that's what the Department of Environmental Services versus Land Use Commission decision said, right? So there really wasn't substantial evidence about the master plan because it's just a conceptual master plan. But you issued that order, and it now requires the development, the infrastructure development by a time certain. So KS wants to be compliant. And what that means is we had to go back and look at the condition and say, well, we can no longer say what you said in 2014, which is do an EIS when it's all over, after the solar farms are gone. Obviously, an EIS will have to be done sooner because the master plan has to come along sooner, along with that motion to amend. So in any event, trying to nibble around the corners and edges of the 2014 conditions just became unworkable. And I think I'm actually grateful that DPP pointed that out, and it gave us an opportunity. And when I say us, again, it's a 3-party stipulation to come up with language for that condition. And I'm talking about condition 10 that both makes it clear that KS is going to be subject to Chapter 343, like anybody would be subject to Chapter 343. And then also includes the Department of Health decommissioning language that OPSD had requested in that initial stipulation. And the second significant change in that stipulation, through the amended stipulation, is the additional language about the landscaping plan approval. If a landscaping plan is required, that DPP would have to approve it. Condition 11 is another example of how the 2014 conditions have been substantially modified, because you might recall, those of you who were on the commission, in 2014, you never imposed a wildlife protection condition. Nothing, nada. This time around, OPSD said, we think that kind of condition should be imposed. KS said, okay, and we stipulated to it. So that's one of the changes from 2014 to today. And when DPP suggested that additional language about the landscaping plan, that was acceptable not only to KS, but, well, I'll just stop there. That was acceptable to KS, and KS intends to have the solar farm developer comply with the language in the condition. So I'll stop there, Chair, just going over the exhibits. I'm happy to answer questions, but again, I know commissioners want to speak to our witnesses as well.
Thank you very much, Ms. Lim. Commissioners, questions for Ms. Lim or her witnesses? Commissioner Giovanni.
Thank you, Chair. So let me start off by thanking you for the aerial photographs of the solar farm that's being built, which is phase 2, I believe. I think you refer to that as completed. It looks to me by the aerial photographs to be 80–90% complete, which I would advise our chair that it looks like this date is going to materialize. The prom date you were referring to for the first solar farm. So that's good news, and thank you for affirming that with the photographs. I'd like to have some confidence building regarding the phase 1 solar farm. So I don't know if your witness from AES is available now.
Excuse me, I believe he is Vice Chair. I'm looking to his counsel. Okay. So as you just heard, Mr. Tabata represents the solar farm development company, and Mr. Nick Molinari, who I mentioned earlier, he's in the public participant Zoom.
Okay, I can admit him. It helps. There's not a lot of people there, so. I'm going to promote Mr. Molinari to be a panelist. Mr. Molinari, when you come in, if you can enable your audio and video. I appreciate everybody's working with us on trying to do hybrid meetings. Mr. Molinari, I'm going to swear you in again. Do you swear or affirm the testimony you're about to give is the truth?
I do.
Okay, thank you. You might speak slightly louder. There's questions for you from Commissioner Giovanni.
Mr. Molinari, great to see you again, albeit by Zoom. I don't know if you can see, I'll wave my hand so you can see where I'm at. What we're really looking for, the Commission's looking for assurances that you're going to build this project, and which is what you represented to us on April 14th when you were before us. Can you provide us an update? We're particularly concerned, you know, with the recent inflationary costs that were being experienced throughout the world, with the removal or with two projects similar to yours that were competitively bid in approximately the same time frame and awarded contracts by HECO, which were approved by the PUC. Those developers are saying they can no longer honor those projects because they're out of the money. What about your project?
Thank you, Commissioner Giovanni. Is my audio okay?
Good.
Is that good? Okay, good. Yeah, thank you for the question, and I apologize for not being able to be there in person. You know, I fully understand your concern, and I think it's been you know, a top headline in the news recently on a regular basis. I would say that, you know, we have you know, our photographs weren't included in this most recent supplement, but we, unlike many of our competitors, have actual operating projects that are similar to the WAIAWA project in the state. 2 operating projects on Kauai that have been you know, internationally recognized and have been up and running for a few years now. Looking at kind of you know, the projects that HECO had awarded, you know, in the phase 1 RFP and then in the phase 2 RFP, we have 3 that are under construction right now, and there should be, you know, publicly available information. You know, we have a project on the Big Island that was in that first RFP that is fully under construction, solar panels, racking, substation, inverters, batteries being constructed. Our West Oahu project that this commission approved for a special permit in June of last year has commenced construction. And then our Kuialani project, which will represent 15% of the load for the island of Maui, has recently commenced construction as well. So we're moving forward. I can't speak to you know, other companies and why they you know, have made the decisions that they've made, or they've had to make the decisions that they've had to make. I will say that you know, AES, as you know, Commissioner, has been in the state for a very long time, operating the power plant at Barbers Point. as well as the renewable energy projects on Oahu and Kauai that I mentioned before. We also have the geographical diversity and also technological diversity that a lot of our peers don't. We don't just do solar, although it's solar and battery is really my focus, and now some hydro too. Our company is diversified across the world in many different markets and also many different types of technologies, which I think puts us in a better position to weather these storms. I'm not gonna stand up here and say that we're immune from all of the supply chain disruptions that are impacting everything, frankly, from consumer goods to electronics to solar to everything. But I will say that we have taken some steps specifically for WAIAWA to try to get out ahead as much as we can. We've invested a significant amount, in the order of millions of dollars in, sourcing components and advancing engineering. And really that's at risk because we don't have the assurance of a commission approval. We're kind of moving forward at risk because that's what we think we need to do. And we're a big enough company that we're fortunate where we can do that. So again, I don't have a crystal ball. I don't know, it seems like every day there's a new headline of some sort of macroeconomic catastrophe, but I would say that, we're better positioned than most to be able to execute this project.
Thank you for that explanation. Can you confirm or share with us, have you secured materials that you need for the WAIAWA project at price points that will deliver for you a feasible project? Or are you still shopping for materials?
Thank you, Commissioner. We have secured a number of materials. I will say we have not secured all materials for the project. A lot of it is, there's the standard stuff that we have, master supply agreements in place with major vendors. Some of the stuff has to be custom built. And so until engineering is far enough along, we even though we have a master supply agreement, we can't officially, make a payment on that order. So we have secured some of the overall, the components that we need. We have not secured all.
Is there on your master schedule for this project, does there exist a go, no go deadline before you make a final commitment to follow through and build the project?
Thank you, Commissioner. Our intent is not whether it's a go, no go. It's how much pain are we willing to live with? I don't know that there's a, if I can point to a specific date, all I know is that the end date is October 2023 when we want to be up and running. If we go beyond that for whatever reason, there's liquidated damages that, aren't deal killing, but certainly don't feel good. So we're again, it's not necessarily a go, no go. The company is very committed to transitioning Hawaii from fossil fuels to renewables. I don't see, so I'll leave it at that. I think we want to move forward on it. I can't point to a specific date.
Not for completion, but for commencement of field activities, physical construction, pending approval by this commission. When do you expect to put a shovel in the ground?
We'd like to put the first shovel in the ground no later than the end of the year.
Okay, Mr. Molinari, thank you very much. And let me acknowledge for my fellow commissioners the important role that AES has played in the state with your projects that you mentioned. very successful projects that has moved this state in the direction of renewable energy. So thank you.
Thank you, Commissioner Giovanni.
Thank you, Commissioner Giovanni. Commissioners, questions for Ms. Lim or any of her witnesses?
I have another one for Ms. Lim.
Please continue, Commissioner Giovanni.
Yeah, I want to go back to I think it's condition 9 in your stipulated, the most recent stipulated agreement, which is the infrastructure deadline.
That's correct.
Yeah, and reaffirm that you would be amenable to a similar condition for phase B for a date of 2035, 12/31/35 for development of infrastructure, backbone infrastructure for parcel B by 2035, should you, as an additional condition?
Commissioner Giovanni, that's a difficult question. So give me a couple of minutes, please. You heard my client, you heard Ms. Sato say at our hearing in, was it back in March, that yes, KS would be amenable, would accept such a condition. And I'm certainly not in a position to back away from that commitment, but there was no decision on the proper time for the phase B infrastructure.
Sorry, for some reason, I've lost your video, Ms. Lim.
You
Thank
know,
you.
that was my fault before. The camera was faced there. I had 2 cameras on me, and I just thought, I'm not that much of an egomaniac. I don't want to look at myself twice and stare.
I noted it, but did not complain for the record, Ms. Lim, so.
Okay, so coming back to 2035, that's very, very soon. I mean, 2035, I guess I would say in the same way that my friend, Mr. Yee, expressed that this is a premature point within which to really get into the nitty-gritty on the master plan, because we have not yet filed the proper evidence. We have not gone through the hard work of putting together that proper evidence for you to be able to make a deliberate and thoughtful and non-arbitrary decision on the time frame for the backbone infrastructure for yet another phase of the master plan when the master plan isn't even before us. I would say 5 years seems pretty soon. This is a matter for the commission's discretion. I mean, and I also know, and I know you all know, that whatever order you issue today is, and let me not say this in a way that imposes any kind of disrespect, but it's going to go out the window, right? Because my client has to come back with a motion to amend to get permission to do anything but solar. That's all you've given us permission to do, solar and nothing but solar. So we have to come back to you. So knowing that, I mean, whatever conditions you lay on this order will certainly impact the solar farm developer. Should have a somewhat short-term impact on Kamehameha schools because of our requirement to come back to you to actually get permission to build the master plan. So I think that the end of 2035 is extremely premature. It doesn't even mesh with the very sort of conceptual Gantt chart development timeline we presented to you. But at the end of the day, this is a matter for commissioner discretion.
So I have a response, but you confused me with your remark about 5 years being very, what do you mean by 5 years?
Well, didn't you say, right now we have an infrastructure deadline for phase A of the end of 2030.
Correct.
And as you know, the master plan is going to be developed sequentially. It's going to be a phase development. It'll go from phase A to phase B. And what I heard you say is we have 5 years after completing phase A to do all of the infrastructure for phase B.
I didn't impose that at all. Are you suggesting that you will not commence infrastructure development, including any engineering work, design work, permitting work, any of that upfront 3 to 4 years worth of work that occurs within a nominal 10-year period? You wouldn't even commence that? until phase A is completed?
I don't think that that's correct. I think that that kind of preliminary, again, the most preliminary work will be through the EIS, which has got to get out of the way right before even phase A. And that's where the more concrete expectations on timing based on actually information that we have. But do I think that if you were saying the start of the infrastructure versus the completion, and maybe I didn't hear you correctly.
So let me explain where I'm coming from.
Please.
The derivation of the condition for phase A was based on a nominal 10-year period that looked out from the decision that was made to approve the phase 2 solar farm, which gave 10 plus years to completion of backbone. I'm looking for a similar condition that says if you want to start on phase 1 of the solar, let's go 10 plus years from now to develop the backbone infrastructure for parcel B. And I actually added a few years beyond the 10 years, and I said 2035. So it seems to me to be more than adequate enough time. And you surely, if you're sincere in developing this overall property, would look to be doing things on parcel A and parcel B in parallel. You wouldn't wait for one to be fully complete before you even did preliminary work on the second one, in my view. Having said all that, I think it's important that we put some hard dates in a condition such as this, even though it would be subject to review and revision when we go to a DBA, as Mr. Yee and I were talking earlier today.
And again, a DBA is likely but not certain, but what is certain is a motion to amend. I want to make sure that's very, very clear, because some commissioners said, well, maybe we don't say yes to a DBA, and that's right, maybe you don't.
Maybe we don't say yes to a motion to amend.
Exactly, exactly. This is all going to be highly discretionary, and it's going to be based on the substantial evidence that we have before you at that time.
And where I'm saying is that consideration of the motion to amend, in my view, would be appropriate to consider in a condition that is consistent with how we did this for the phase 2 solar farm. You want a phase 1 solar farm? What this commission is really interested in, and you've heard our frustration over and over at these hearings, is housing. When are you going to start on the housing? Solar farms are great. You get some revenue, it helps pay for everything. We get that. It helps with the energy transformation within the state. We get that. You've got some really good solar developers. We get that. We support it. These are great projects. I'm wholeheartedly in support, but I cannot lose sight of the importance of the development of housing on this important land. We've been talking about it, not me, but this commission has been talking about it since 1987. So we want to move it forward, okay? And it's all, so that's where I'm coming from.
So let me make sure I'm being clear. I'm giving you a position to say that putting an additional time frame for development on phase B of the master plan won't really accelerate things, right? Because the acceleration is that condition is already on phase A. And darn it, once you put in the millions of dollars it takes to go through the entitlements process, and then the multiple millions of dollars to put in that infrastructure, you don't just stop. So what I'm saying is that the phase B infrastructure seems not only not really tied to the evidence.
I don't think I saw any of that in your Gantt chart for phase B.
Any of the.
You're suggesting that once you start, you don't stop, and it should have showed up in your Gantt chart for phase B, infrastructure development.
It is in there. We can pull that up with you later. Okay. But like I said, I want to be very clear. You heard my client, and by my client, I'm referring to Ms. Sato, say at the hearing in March, after an initial reaction, I think reflective of some of the thoughts that I'm saying to you now. Her initial reaction was, whoa, no, we shouldn't have another condition about timing. But then you heard her say, upon reflection, a condition would be acceptable.
I clearly heard that.
So that is, I mean, I represent Kamehameha Schools. Of course, my position is consistent with Kamehameha Schools' position. And,
sorry, just for the record, you're both talking over each other at certain points. So.
And the time frame would, of course, be at your discretion. I think 5 years past the completion of the Phase A master plan infrastructure seems extremely fast. At the same time, to repeat myself, I think all or most of these conditions are going to be substantially revised when you're actually asked to deliberate on the master plan. So if the commission thinks that 5 years is going to somehow, the 2035 deadline is going to somehow make things move faster, and that makes the commission from a policy perspective think that it's doing what it needs to do, then so be it.
So I did hear Ms. Sato's two comments at the last hearing. One in which she said she was not amenable, and then after reflection over the noon hour, she came back and said that Kamehameha Schools was amenable, and we were very pleased with that response. We can debate whether that is a reasonable amount of time. I particularly think that looking out 13 years from now is a reasonable amount of time if you're serious about doing housing on Parcel B. That's my position.
Understood, Commissioner, and I know it continues to be very difficult to see the Gantt chart.
Very difficult and very high level, I might add.
It is, again, because we're not at the point of actually bringing forth the master plan for your approval. That'll be done via the motion to amend. But if you can see, and I've got to move it a bit.
You have to increase the percent.
I'm pulling up another copy on my own computer, and you can see here the Phase B design and permitting is starting in 2036, 2038. And I believe vertical construction in the gray box, vertical construction is projected to start in 2038 for Phase B. So we're not wildly off from the time frame that you're proposing, Commissioner Giovanni. It's a little bit different. And like I said, this is all going to be much further refined. Ultimately, it's your discretion, and my client has already said that if an infrastructure deadline on Phase B of the master plan seems appropriate to the commission, then so be it.
So it seems like we have two choices. One is to accept this time frame, and then when the master plan comes before us, to argue to accelerate it, or for us to put in the time that we think is reasonable today, which I happen to think is to be completed by 2035. And then when you present the master plan, give you the opportunity to argue to revise it accordingly to a later date. Those are our two choices.
I wouldn't disagree with what you said.
Thank you. Chair, I have no further questions.
Shall we take down the Gantt chart, or?
Yes.
Commissioners, questions for Ms. Lim. Mr. Yi, you haven't been elevated to be a commissioner yet, though. In your retirement, I would encourage it strongly. But do you have a procedural matter?
I was wondering, in light of the additional questions of Mr. Molinari, we might be able to cross-examine based upon the questions that he gave.
I'm having a hard time hearing you.
I'm sorry, I was speaking softly. I was wondering, given if we could cross-examine Mr. Molinari based upon the questions he gave today. Obviously to the commission's decision.
You know, I believe it would, in the fullest sense, facilitate our deliberations interaction on this matter. Any objection, Ms. Lim?
No objection, thank you.
Let's do that right now, and then we'll go back to Commissioner's questions for Ms. Lim and any other witnesses. Mr. Molinari, you're under oath. Mr. Yi.
Thank you. Mr. Molinari, you were asked various questions about the viability of the project. And I think all of us have read the Civil Beat article. So let me just see if I can ask a few direct questions about it. AES has PUC approval for this project, is that correct?
Yes, AES has PUC approval for the 20-year power purchase agreement.
And did AES ask for a modification to increase the rate?
AES did not request a modification to increase the rate.
AES did ask for a rate increase for another project though, is that right?
Yes.
And in the other project, the argument, or at least one of the arguments being made was that AES needed the higher rate in order to make the project financially viable. Is that right?
No, not exactly, Mr. Yee. The circumstances, I would say, of that particular project were fairly unique and different than, you know, the motion before us right now. In the case, I don't know how much. Well, this is what I can share about that. The request was driven by a completely unforeseen force majeure event where AES had basically secured solar panels. A new policy was put in place by the federal government, enforced by the U.S. Customs and Border Patrol, which basically put a stop on solar panels that were alleged to have raw materials coming from a certain region in China. As a result of that matter, the solar panels, the manufacturer of those solar panels for that project essentially pulled out. And it was a very clear force majeure event. So we came with, kind of two options, which was, we had an alternative, panels that had already cleared customs, that were in the United States, that were not subject to the allegations and the impacts of that event. They would come at a slightly higher cost. We could secure those with approval of a rate increase, and keep the project on, while there was a disruption, a delay, it was not as significant as it could have been if, we elected to, just wait it out and wait for, full resolution on the matter. So our counterparty, Hawaiian Electric, the Public Utilities Commission, had to kind of weigh the matter, which was, we can secure these alternative panels and bring them now, or we can, which comes at a cost increase, or we can, wait for the event to clear itself out. That is not it's not the same issue here at WAIAWA.
But so basically, in order to proceed with the other project without delay, you needed a higher rate in order to secure the panels that were available now.
Correct.
And you have not asked for a rate increase for this project, correct?
Correct.
So would that then be an indication that AES believes that it does not need a rate increase at this time in order to make this project viable and to proceed with this project?
Mr. Yee, at this time, AES believes that it does not need a rate increase. That being said, I get, like I said in my response to Commissioner Giovanni, I don't have
a crystal ball,
and I don't understand.
I'm not asking you to predict the future. I'm only asking you to explain what the situation is today.
Yes, understood. And I would also add that, while I certainly appreciate the line of questioning, absolutely, I understand and share, many of the commissioners and your, anxiety around the recent headlines around these projects. Any project that has to propose a rate increase, would be, as the chair of the Public Utilities Commission has pointed out, would be heavily scrutinized by that body, as well as the consumer advocate, before any potential approval was granted for a rate increase.
My final point is simply, or question is, so then the situation in this project is different than the situation in the other project regarding questions about financial viability. Is that right?
I would say the situation is different. I'm not sure. Maybe can you reword the question just so I understand?
There are concerns that were raised in the Civil Beat article as to whether the solar projects are still financially viable. And in your other project, you got a rate increase and you're proceeding with that project, correct?
Correct.
And in this case, you don't feel you need a rate increase at this time and are proceeding and are prepared to proceed with this project, correct?
Correct.
So the concerns raised by the Civil Beat article about solar farms generally would not be applicable to this project. Would that be your opinion? I'm sorry, I shouldn't say so generally about concerns. Because I think everything can have a concern, but this project is, in your opinion, prepared to move forward despite the concerns raised in the Civil Beat article.
Yes, that's correct.
That's it. Thank you very much. I have no further questions.
Thank you, Mr. Yee. Trying to assess procedurally where we are here. Ms. Lim, any redirect before we go back to the commissioner's questioning of you? Any redirect for Mr. Molinari?
No redirect, thank you.
Okay. Commissioners, well, we're actually at 10:49. I'm going to propose that we take an 11-minute break, reconvene at 11 a.m. for continued questions on Ms. Lim regarding her additional evidence that was put into the record. Does that sound good, commissioners? Okay, I see heads nodding. We are going into recess till 11 a.m. Okay, it's 11 a.m. Are we ready? Parties, County, Pang. Okay. Commissioners, looks like we're all good. Mr. Ordenker. Dan O. Okay. 11 a.m. Let's go back on the record. We're continuing with questions for Ms. Lim following the introduction of her additional exhibits. Questions from the commission. Commissioner Chang.
Yes. Thank you, Mr. Chair. Thank you, Ms. Lim. I may end up having to apologize in advance, but I saw your exhibit 54, which was the aerial of the solar project that's currently actually almost looks completed. Is that correct?
That's correct.
Is that parcel within the area, the original petition area, or is that land that needs to be subject to a new DBA?
So that is within this petition area. It is within the existing 1,395 acre urban district area that got reclassified in 1988. That area where the solar farm is completed, that's the same location, the phase 2 location that this commission approved for solar farm uses in 2014. And that was the motion, you recall, we filed in 2019, and then we had hearings both in 2019 and then concluding in early 2020, right before the pandemic, to get permission to refresh the permission, because the original solar farm developer, SunEdison, ran into difficulties. And in fact, there were some changes between the kind of solar farm that SunEdison wanted to build and the kind of solar farm that Clearway wanted to build, most significantly battery storage.
Yeah, no, the reason I asked the question is it was not clear during the original presentation, at least to me, that the degree to which that project has proceeded. I apologize. I'm certain the representations made by you and others were that it was under construction. Because in my mind, it does go to my concerns about substantial commencement. I mean, you have started to use that portion of the project. Is the petition is the area for the second solar farm being proposed by AES, is that also within the existing petition area?
It is. The area for the current project, the one that we filed the motion that we're here about today, that's the phase 1 site. It's about 387 acres. Again, it's the same area that you folks approved for solar in 2014.
All right.
And it's all within the existing urban district lands.
All right. Okay. Thank you. I appreciate that clarification. And I apologize, like I said in advance, it was not clear in my mind that there had actually been substantial commencement of use of the property to the degree that your exhibit 54 shows.
Apologies for failing to make that more clear.
Thank you.
We threw a lot of information at you.
Chair, this is Giovanni.
Please proceed.
I have just a quick clarification on that last point. Ms. Lim, can you confirm that Parcel A and Parcel B are not at all affected by either of the two solar farms on phase 1 or phase 2?
So I'm going to answer a little bit of a different question from what you asked, because you use the term Parcel A and Parcel B. And if you remember the solar farm that we're here about today, we actually have bifurcated into two pieces, Parcel A and Parcel B, for reasons that I'll explain in a second. But I think what you meant to ask me, and perhaps we can pull up an exhibit, I'll suggest an exhibit in a second. I think what you meant to ask me is the master plan phase A and phase B.
I do.
So phase A is at the most southern point of the Kamehameha Schools urban district land, is not impacted whatsoever by either of the two solar farms. Phase B, similarly, not impacted whatsoever by either of the two solar farms.
That's an adequate response. I don't need anything more. That is consistent with my understanding.
Okay, thank you. So I won't pull up any exhibits to facilitate.
Well, in essence, you're saying that you can proceed on development of infrastructure for those two parcels without having to modify, tear down, or affect the solar farms.
That is correct. That is exactly correct. And recall, with the current solar farm, the reason why this piece, this 387 acre area, and again, it's not a separate parcel at this point, but the reason why it's bifurcated into what we're calling Parcel A and what we're calling Parcel B is because KS wants AES to get out of there. They want Parcel B solar farm decommissioned and gone so that it doesn't impede Kamehameha School's progress with the master plan. So we start at the south on the master plan with phase A, then it goes into phase B, then it's going into phase C. Well, AES, got to get out of there. The timing works such that they would need to be off of the fully decommissioned on the Parcel A portion of the solar farm by the end of 2044, and then on the Parcel B portion of this solar farm 2054. And again, that's so that the solar never impedes development of the master plan.
Understood. Thank you.
Mr. Chair, can I ask a follow-up question?
Please go ahead, Commissioner Chang.
Sorry. Thank you. So Ms. Lim, just to put in my mind a closure to what Commissioner Giovanni, the line of questioning, and the infrastructure. The infrastructure deadline or your constraints is really based upon the completion of the EIS. Is that correct?
Largely, it's also based upon not only the EIS, which
We're getting a lot of feedback. I apologize. I'm not sure where it's coming from.
I hear it too.
There might be a commissioner's microphone that's on that doesn't need to be on. Okay, go ahead, please. Sorry.
So it's completion of the EIS, and then, as I said earlier, we need to return to you to get permission through a motion to amend to do anything on this property other than solar development. That's the condition that you put on us in 2014. So what is precluding us from moving ahead on the master plan is following the law, doing a Chapter 343 EIS, then coming back to this commission to get permission to build the master plan. And at that time, we fully expect that issues of timing, issues of infrastructure, issues, all kinds of issues, and will be raised as they typically would be when you're really looking at a development proposal. Then with that motion to amend, it's likely at this point that there will be an accompanying district boundary amendment. But again, the district boundary amendment may or may not be pursued, whereas the motion to amend must be pursued if we're to develop. And then recall Ms. Swartman explained last time, we want to return to the city and actually redo the zoning. So the property's been rezoned. There's zoning ordinances that have rezoned it for development, but the development that is permitted under those rezoning ordinances is development that was conducive to what Gentry wanted to do with the 2 golf courses and the leisure village and everything, which is very different from what Kamehameha Schools wants to do. You know that they're looking at a much more compact development. So it's EIS, Land Use Commission, city and county zoning, subdivision, building permits, but those are the hurdles we have to jump through before we can stick a shovel in the ground.
I guess my only point is that those are all within the control of Kamehameha Schools. It does not require, although the motion to amend to permit you to proceed is would come before the Land Use Commission, the rate and the speed upon which you proceed, that's really up to Kamehameha Schools. So the deadlines for the infrastructure, while it may appear to be ambitious, is really controlled by Kamehameha Schools. That the deadlines placed by the Land Use Commission, while they may appear to be arbitrary or too ambitious, is because I guess I just would like there to be. And I know you realize this too, that the commission's frustration, while Kamehameha Schools has just recently come upon this property and developed it, it has really been pending for many years. So we're really not trying to give Kamehameha Schools a hard time. We would have required this of anyone. But these are all things within the control of Kamehameha Schools at this point in time. Assuming that this motion gets granted and you're able to build the solar, there's nothing to preclude Kamehameha Schools to proceed aggressively with the environmental documents to permit you to proceed. Is that correct?
Commissioner Chang, I absolutely agree with you on that. This motion needs to get resolved because to engage in the proper environmental review, we need to know what's going on the property. So we know we have this approval from 2014 that allows a solar farm, okay? But the approval that we're seeking right now would actually allow a portion of that solar farm to stay on for 5 years longer, and a portion actually has to get removed 5 years earlier. So we need to get through this hurdle to be able to engage more full-throatedly on the EIS, but that's not to say that work hasn't already begun. You heard Ms. Swartman report to you all at the last hearing. PBR has been engaged. Sub-consultants to Kamehameha Schools have been engaged. PBR hasn't yet engaged their sub-consultants on the EIS. I mean, there's work happening, but we kind of just need to move past this kind of impasse that we're at right now. And then the EIS, it'll take as long as it takes, but you're correct. I mean, if people are committed, it becomes a matter of how overwhelming are the public comments, how complex is the alternatives analysis.
So let me ask you this question. If the commission does not approve, based upon what you were just sharing with me, if the commission does not approve this motion to modify, is that going to stop Kamehameha Schools from proceeding forward with their master plan?
I don't think it's going to do anything one way or the other with the master plan. In the same way that the solar is not impeding development of the master plan, a lack of solar, while it would be extremely unfortunate for a number of reasons that I'm happy to discuss, but the lack of solar would not necessarily impede development of the master plan. Obviously, there's financial impacts and renewable energy impacts, but
Yeah, and I'm not suggesting that that's the position I'm taking. I guess I just wanted to respond to, until we resolve this, we can't move forward with that. So I just want to be really clear that this, the commission's addressing the petition, that's the motion that's been before us, the time period that we spent on this, should not in any way delay Kamehameha Schools from moving forward on their master plan. And as you said, representations is that they have been. So I just want to be very clear that we're not necessarily holding up the master plan.
I'm not saying you are, although for a proper environmental review, and by that I mean when something is published, you do have to describe the facts on the ground. So there is that question mark, but in terms of the sort of the preliminary work, I wouldn't disagree with anything you said.
All right, thank you.
Commissioners, further questions for Ms. Lim at this time?
Yes, Commissioner Cabral here has a question, if I can ask it.
Thank you. Please, Commissioner Cabral.
Okay, I know you can't see us all waving over here. Yes, Petitioner Lim, thank you very much for all this wonderful information. What I keep my stuff, and I brought my pictures from last month and my charts. And so I want to just verify, because in those, of course, they're big and I'm so familiar with them. And you have a large number of timelines and it laid out, but yet since then you've submitted a couple more documents, including the unnamed Exhibit 58 today that we received. Has any of the new information you've given us since we were together in mid-April changed any of those timelines on what you were planning on doing, or to what areas you are planning on doing any of this development for solar and or for future housing?
No, Commissioner Cabral.
Okay, thank you very much. I just don't want to be looking at the old data. Thank you.
Thank you, Commissioner Cabral. Commissioners, further questions? Ms. Lim. I'm seeing none, but you're all very, very tiny on my screen. Audio, any questions? Commissioner Wong?
Chair.
Yeah.
I would like to make a motion to move to executive session to consult with the board's attorney on questions and issues pertaining to the board's powers, duties, privileges, and immunities and liabilities regarding substantial commencement and any other appeals that may occur.
Thank you for the motion, Commissioner. I'd like to know, I do have a short line of questions for Ms. Lim as well. I'm happy to take those now or later.
Sure, I'll hold it until after your questions. You may cancel my motion.
Okay. If there's nothing else from the commissioners, I'll go over this fairly quickly and then we'll take up Commissioner Wong's motion. Ms. Lim, you heard my questions and comments at earlier hearings about my concerns about the differences between an environmental impact statement under 343 and a real community-based master plan. Is that correct?
I did hear your comments. Yeah.
And the stipulated condition, now a three-way stipulated condition, does allow for the EIS to substitute for a master plan. So I guess my broad first question is, was there consideration of perhaps separating out the master plan process with the EIS process? And if not, why not?
To be perfectly frank, that there wasn't a discussion about separating those out, and I'll explain why. Notwithstanding your comments that a master plan is somehow more robust, we know that for this EIS, we have to do an awful lot of analysis, and as well as community consultation, as well as just the purely public process that starts from the scoping meetings and goes forward from there on the EIS. It seems to me that if an EIS is going forward, and you heard from Ms. Swartman the kind of community consultation that they intend to engage in to start off that EIS, that it would provide the kind of information that I think you would be seeking in a master plan. For instance, I've worked on several 343 documents. I often consult with clients as they're going through that process. And certain clients have whole appendices describing community meetings, describing groups that they've met with, feedback that's been received. And why is that? Because ultimately, although it's a technical disclosure document and it's a legal disclosure document, nobody wants to get bopped over the head at a final decision on an EIS and find out that, because we didn't beat the bushes well enough, there are people who are really objecting to the acceptance of this EIS, or there's people who are going to challenge the validity of this EIS. So to me, it's quite a back and forth kind of iterative process, because if you don't beat those bushes, especially on an EIS that covers a project of this size, chances are you're going to find out you're going to get some pretty bad surprises later in the game. So that's the perspective. I don't know that we would be opposed to breaking out a master plan from an EIS, but when you know that the EIS is being done because we have to come to you with a motion to amend to get your approval of the master plan, and you, of all people, being on this commission for 8 years, know how substantial those kind of proceedings are. There could easily be rooms or screens, hundreds of people who want to participate, who want to provide testimony, et cetera, et cetera. To me, the EIS, because it feeds into the motion to amend, is actually going to be, by necessity, an extremely comprehensive document that involves, a lot of community involvement.
Thank you for that response. So I'll just preface my reaction to say, like, this is ultimately not for me. This is for a future commission. I'm going to be off the commission when you guys come back. And presumably not put back on, because I think I might say no, even if they asked after 8 years. But it'll be for another commission, and I want this commission to have the best possible experience. I think when our EISs have gone smoothly, it has been when, and I hold up Waikapu Country Town as an example. They spent a lot of time and a lot of community engagement before they started the EIS process to figure out what was going on. I have the sense here that Kamehameha Schools is starting the EIS process and then waiting to sort of do some of the more robust community engagement as part of that process based on the testimony from Ms. Swartman and others. And it just gives me pause, and I'll just use this brief opportunity. Right, my engagement with this project, I mean, it was approved. It was applied for the year I graduated from high school, which is now 35 years ago. It was approved my first year in college. My first engagement with it was when I was working for Kamehameha Schools. Kamehameha Schools had unsuccessfully argued in front of the State Water Commission that they should get water from the WaiaawA ditch in order to feed the development here. I was tasked with working with particular community members on revising Kamehameha Schools' water policy to actually reflect more than just a raw ownership claim to water, which KS had pursued, but instead a recognition that water resources have educational, cultural, economic, community values. I then, working for the Office of Hawaiian Affairs, despite the fact that it was Gentry's development, represented the Office of Hawaiian Affairs when Kamehameha Schools tried to get its water use permits for their golf courses, which they eventually did get. And now it's come in front of me multiple times on this thing. I've said this before, so I'll just touch on my earlier remarks in response to one of the case witnesses. This continues to be kapulu. This continues to be sloppy and difficult because of the failure, in my mind, for Kamehameha Schools to meaningfully engage with all the stakeholders who are appropriately involved. So this condition gives me great pause. It does not necessarily accomplish the robust, thriving ahupua'a that we want to all see here. I'll give you the opportunity to react, but that's all I have to say about that first stipulated condition. I don't think it achieves what we need it to achieve.
Well, obviously, I mean, your thoughts as somebody, especially with the history, the professional history that you have, are very meaningful. And I also go back to what you just said about the Waikupu properties docket. Some of these commissioners know that some of us have had a very hard time on an EIS that came before this commission. We have the scars of knowing what happens when we work with clients who had the very best of intentions, but there was some failure with community consultation at some point. And those scars teach us a lot. Kamehameha Schools has been public about this. If I remind you, and we refiled a copy of it, but Exhibit 42 in this docket is actually a copy of the master plan and schedule for development that we filed in October 2019. It does have a long list of stakeholder meetings that had taken place at that point.
I'm familiar with it.
And that list was not quite duplicated on the PowerPoint that Ms. Fortman walked you all through at the last hearing. More work has to be done. There's no doubt about that. I struggle to think how the stipulated condition would be changed to encourage what is already going to happen if we want to be successful before this commission. You know, no matter who's the chair, we're going to need support, not only from the commission, but from the community. We're going to need people who are willing to come before this commission and say, this is a good one. Please vote yes on this one. And that's only going to happen if that kind of meaningful engagement takes place. So I struggle to think about how conditions should be changed to tell us what we need to do if we want to be successful. If there's a proposal, I would be happy to confer with my client on suggested language, but just know that with or without a condition, if we want to be successful, we got to do that work, and we know it. And a condition isn't going to make it happen any better or any worse. We need to do it no matter what.
Thank you, Ms. Lim. Commissioners, anything further before we take up Commissioner Wong's motion? Seeing none, there's a motion made by Commissioner Wong to move into executive session to consult with the Commission's attorney on our powers, duties, liabilities, and immunities related to our ability to revert. Is there a second?
Second.
Seconded by Commissioner Ohigashi. Is there any discussion?
Chair, this is Gary Okuda.
Commissioner Okuda.
This is one of the few times I'd like to speak against the motion to go into executive session.
Please proceed.
Thank you, Mr. Chair. Unless the Deputy Attorney General, Mr. Morris, is going to tell us that he has anything additional to add to Mr. Yee's responses to my questions about the effect of substantial commencement in context of the Bridge Ainalea case. I'm just concerned that when we go into executive session, it's just going to involve deliberations on how that rule would be applied to this specific case. And I think that type of discussion should be out in the open so everybody can hear the reasoning. So for that reason, unless Mr. Morris intends to give advice contrary to what Mr. Yee has testified to, I'll be voting against this motion.
Thank you. Commissioners, further discussion on the motion to go into executive session.
Mr. Chair, this is Commissioner Wong.
Commissioner Wong.
Just one thing. If we do go into executive session for everyone here, just because my stomach is getting hungry, can we have lunch at the same time so everyone can have lunch during, if we do go into executive session?
I'm ahead of you on that one. I was going to suggest that, Commissioner Wong, but let's deal with the substantive. Anything further on the substantive motion? Commissioners, we're in discussion.
Mr. Chair,
Commissioner Ohigashi.
supporting the motion to go into executive session. I hear Mr. Commissioner Okuda's concerns. However, I don't know what Mr. Morris will say. And I've been in executive sessions throughout these commissions, and it would seem that the Attorney General, as well as our Executive Director, would put the kibosh or would stop us from making any kind of deliberations. And knowing the rest of the commissioners, I don't think that any kind of deliberations will take place. So therefore, I think it's helpful to get Mr. Morris's. And besides the fact, I don't think Mr. Morris can restate his advice to us, so that if he did, then we wouldn't need to go into executive session.
Mr. Chair, this is Gary Okuda.
Commissioner Okuda.
Yeah, Commissioner Ohigashi's convinced me that I should reconsider what I said, so I withdraw my objection.
Okay. Is there further discussion, commissioners? So I'm going to ask Mr. Ordecker to do a roll call vote on the motion to go into executive session, and I will suggest that we encompass the lunch break within executive session. I will need some assistance with somebody who's physically in the room at the airport to advise on how where the commissioners will gather for executive session and how the virtual link for executive session will be distributed. Who can advise us on that? Mr. Ordecker? Or who? Scott? Riley?
Thank you, Mr. Chair. I believe that Natasha Quinones, the chief clerk, has already sent a link for executive session. To at least I've received one. She sent it just a few moments ago. So what yourself and Dan Morris and myself will link in by Zoom, and the remaining commissioners will stay in the room. We're going to have to ask the parties and any public to leave the meeting room at the airport.
Okay, so the room at the airport will be cleared for except for the commissioners and council, and then staff, and then okay. And then, sorry, timing wise, it's 11:30, 12:15.
Yes.
Okay. Okay, should this succeed, that will be our plan. Mr. Ordecker, please poll the commission.
Thank you, Mr. Chair. The motion is to go into executive session. Commissioner Wong.
Aye.
Commissioner Ohigashi.
Yes.
Commissioner Okuda.
Yes.
Commissioner Kamake Ohelo.
Aye.
Commissioner Giovanni.
Aye.
Commissioner Chang.
Aye.
Commissioner Cabral.
Aye.
Commissioner Axon is absent. Chair Schroyer.
Aye.
Thank you, Mr. Chair. The motion passes unanimously with 8 votes.
Okay, people, we are going into executive session. It is 11:30. We will reconvene at 12:15. Thanks to all the parties. So this, just to be clear, what should also happen logistically is this Zoom link should remain up. And Some of us will leave this, go into a different virtual room, and then come back to this room.
Sorry, just so I'm clear, should we leave the Zoom link?
You may stay in the Zoom link.
So I won't be able to hear. I'm just
It's 12:20. We're back on the record. I apologize for the 5-minute additional delay. We have exited the executive session and are leaving our continuing questions for Ms. Lim on her evidence, if any. Commissioners, is there anything further for Ms. Lim at this time? Commissioners? If I'm seeing none, then what we would do is we would move on to to closing argument and final rebuttal. So we'll go through the parties and I'll give you a final bite at the apple after that, Ms. Lim. So closing argument. Ms. Lim.
Thank you, Chair. Commissioners, thanks for all of the time and hard work that you've put into this motion. I hope you come to the right decision, which is to please approve this motion. You know that this is an important solar farm project. It's not going to be the one and only answer to Hawaii's renewable energy needs, but it's a step in that direction. And it's a renewable energy farm that's located in an area that this commission's already approved for renewable energy just in 2014. All we're looking for is, as I said before, 5 years longer for part of the project and actually 5 years shorter for part of the project. That's what the motion is before you. Now, there's also been some comments or suggestions that this motion is also looking to get relief from conditions that were imposed in 2014. I take issue with the characterization of what we're doing as seeking relief, because that implies, at least in my head, that we're trying to get away from prior commitments or obligations. In fact, the conditions that we're seeking to change are essentially clean up those conditions from 2014, because several of them have already been satisfied. In 2014, when you told us that we had to have an approved, SHPD approved archaeological inventory survey in place, that was a condition. That archaeological inventory survey has been done. All 1,395 acres have been surveyed. And in fact, not only has the AIS been done, but a preservation plan has been prepared. And that's been accepted by SHPD. And in fact, as the record shows, the interim preservation measures for the 2 solar farms have already put into place. So the conditions that we're seeking to modify through our motion are not, that's just one example, but they're not conditions that we're saying, hey, we can't do it, it's too hard. It's really just looking to clean up things that made sense in 2014, but no longer quite make sense the same way because progress has been made on the solar farms. Now, some of the conditions are not reflected in our motion, but some of the conditions that we're asking for your approval of are those that are shown in the 3-party amended stipulation that we filed yesterday. I already mentioned those, but I'll just briefly touch on them again. Those stipulated conditions retain the condition that you all imposed in 2020, saying that the backbone infrastructure has to be in place in the phase A of the master plan. Even though we're not looking for your approval of the master plan yet, that condition would remain in place for this solar farm. In other words, KS has accepted that condition and proposes to have that be part of your order on this motion. The stipulated conditions also include an extensive wildlife protection measure that was never requested by the commission in the past, but certainly Kamehameha Schools and the solar farm developer are prepared to go forward with the terms of that condition. There's also a condition that initially we thought, why should we prepare yet another master plan when a master plan has already been presented? What we really need to do is get to you with the real stuff, the harder stuff, the EIS stuff, and hurry up and get to you with a motion to amend. Right now, the stipulated condition that all three parties agreed to says, well, we want to see that draft EIS by a time certain, and if not that, a revised master plan. But darn it, let's go toward that draft EIS, if not even sooner than the date and the stipulated condition. In other words, what I'm trying to say is that the conditions that we're seeking modification of are not modifications, as I said, because we're trying to get away from something. We're trying to have you give us a break and excuse us for non-compliance, non-performance. We're simply looking for edits to change conditions to reflect the current conditions, and in fact have voluntarily accepted additional conditions through that stipulation. This is a 30 megawatt solar farm. Now, that, like I said, that's not going to solve every sustainable energy problem in the world, but it's what, about little over 1% of the renewable energy contribution on this island. I think that's what Commissioner Giovanni corrected me on at the first hearing in response to what Cameron Black of the State Energy Office had said. The State Energy Office is in support of this project, and I think for good reason. Not only is it a clean renewable energy project, it's a project that is proposed by a strong developer with a proven track record. It is a project that in no way is going to impede development of this master plan, as we've indicated to you before. And it's a project that is going to, in fact, help fulfill, I believe, this commission's public trust duties. Even though some people may view the most recent In re Maui Electric Company decision from the Hawaii Supreme Court as not an especially scintillating decision, there's language in that decision reminding from the Hawaii Supreme Court reminding us that public trust also includes using our natural resources in beneficial ways to promote the sustainability of the people of Hawaii. And I think allowing this land to be used on an interim basis for renewable energy will help fulfill those public trust duties and will in no way impede the development of housing. I've spoken so much about the exhibits, and I'm very happy to respond to questions, but I want to be respectful of your time, and I'm not going to repeat myself. I just ask that you please give us a fair hearing, understand that we came in good faith with the understanding that this land's already been approved for solar. And we're really just trying to make a few little changes so that this particular solar farm, which is a little bit different from what you already improved in 2014, can go forward. And I hope that, that this commission can make the right decision. I'll stop there.
Thank you. Any final questions for Ms. Lim? If not, Mr. Pang, any closing?
Thank you, Mr. Chair. Very briefly, the City and County of Honolulu Department of Planning and Permitting does not oppose the motion, supports the interim use, and should the Land Use Commission approve the motion, we do request that the conditions in the stipulation be attached to the decision. Thank you very much.
Thank you, Mr. Pang. Any questions for City and County of Honolulu DPP? Mr. Yee.
Thank you. I honestly had made final arguments essentially at the last hearing, so I'm not going to repeat myself. We basically were arguing that the motion to amend should be granted, that there were a number of very difficult issues, but we believe that they should be dealt with on the motion to amend, not today. I won't repeat myself and I won't go into the arguments on why, and I'd be happy to answer any questions about them. There were three particular issues that were raised today. I just want to touch upon them briefly. One was the issue of substantial commencement. Perhaps Commissioner Chang is satisfied with the issue. If so, I am as well. She did ask me for language. If you wanted language, I'd be happy to provide it. But as I said, if you were satisfied with the responses, I will leave it there. The second issue was raised, I thought, by the Civil Beat article. I just wanted to point out that I believe Mr. Molinari demonstrated that this particular project is financially viable, and that the concerns raised in the Civil Beat article are applicable to this particular project, and that it is, I mean, no one has a crystal ball, no one knows for sure, but based upon the information we have now, this project is reasonably capable of moving forward. And finally, there was the issue of whether or not an EIS is an appropriate substitute for a master plan. I understand the issue. It's a fair question to raise. The Office of Planning's judgment was somewhat, while we certainly agree, a well-done EIS, robustly vetted through the public, leads to a smoother district boundary amendment, or in this case, a motion to amend. We believe that it is important to get this project moving forward. And an important part of that was the EIS. That's the reason we wanted to make sure that EIS has a deadline. So we understand the argument about the importance of a master plan, and that the two things are not the same. But it was important to us to get this project back before the LUC, and then an EIS was important to have a deadline for. We stipulated to the condition for it. We stand by that stipulation. And with that, I will stop and be happy to answer any questions.
Thank you, Mr. Yee. Any questions for the Office of Planning and Sustainable Development? Commissioners? Commissioner Chang.
Thank you. Mr. Yee, and thank you for remembering the question that I had posed to you. I went back and looked at 205-4G and Bridge Ainalea. So
the staff might need to, or you might need to turn down the mic slightly for the feedback.
All right, let's see if this is better. All right, thank you so much. So, I am still interested in hearing some proposed language, because I think I, like you, really would like to support Kamehameha School's ability to do this, the solar project. But I appreciated the aerial photo, as that did reassure in my mind that there's been use of the land, commencement of use of the land. But in reading through the specific language in Bridge Ainalea, as well as in HRS 205-4G, substantial commencement of use of the land in accordance with such representations. Such representations, in my mind, go back to the original project, the original DBA that was approved, which was a housing development. The solar projects were not part of that. I do recognize. So, I mean, I would like your assistance in, if you have language as a condition that recognizes that the solar projects, as indicated by the petitioners, are interim temporary use. They're not associated, they're not dependent on the master plan. The master plan can move separately, but yet, if the deadlines are not met, do we still have the option to revert? So I am curious to hear your language.
So as you may recall, my suggestion was simply to defer the question and to make clear. I think you had a concern that the decision today would prevent you from moving forward in the future. So I proposed the following language to make sure that you had the freedom to make an appropriate decision in the future, rather than to make a particular finding today. And the language, if I could just read it, because I'd worked on it while we had some time, would be: one, there is no pending allegation that that petitioner is in violation of any condition or representation. 2, it is premature to determine whether the commission should or has the authority to revert the petition area for violations of any condition or representation. And 3, nothing in this decision order shall limit the commission's ability to determine whether the petition area may be reverted if there is a violation of any condition or representation. It simply makes clear that the issue is not resolved today and will be resolved if the matter ever comes up. I will also represent to you that although I cannot commit OPSD to a position in the future, I will say that my recommendation would be that if Kamehameha Schools just out and out violates one of these conditions, my recommendation would be to fight for reversion if it occurs prior to the motion to amend.
No, thank you. I appreciate the proposed language. Would it be helpful to include in there that the approval of the solar farms are really, they're an interim temporary use and they are not part of the representation, the original representation?
I think it would be important to say that this is temporary interim use and that it is separate and different from the proposed construction, different from the original construction proposed.
Okay.
That what is being substantially commenced is not the original construction.
Okay. Thank you. Okay.
Thank you, Commissioner Chang.
And Mr. Chair, I'm really sorry. I don't know if anybody else has any other questions for Mr. Yee. I had one question from for the petitioner that I forgot.
Okay, I have a question for Mr. Yee. So any other questions for Mr. Yee? Mr. Yee, I just want to make sure I appreciate your comments and you're reflecting on my concerns about the difference between an EIS and a master plan. I just wanted to confirm from your statements that you're not suggesting that due to your client's desires to have an EIS commence so that the project can commence, you're not saying that it is mutually exclusive. It should be possible for the petitioner with the stipulated condition to have an excellent master plan that meets the kinds of stakeholder engagement that we have discussed, as well as meet the deadline for having a draft EIS as stipulated?
They're not mutually exclusive. If that was your question, you can certainly have both.
Yeah. Within this deadline, you believe it's possible? Sorry.
I'm sorry. I will stay quiet. Could you repeat the question?
You believe both are possible within the deadline that has been stipulated?
Yes, I do, but I just have to say OPSD stipulated to a condition and we stand by the stipulation.
Okay, thank you. Ms. Lim, you willing to answer one more question from Commissioner Chang?
I welcome any questions.
Commissioner?
Thank you, Ms. Lim. Actually, this is it's an additional condition and is specifically related to the protection and preservation of Native Hawaiian traditional and customary practices. So this is the proposed language. I'm going to ask if you have any objections. Petitioners conducted an AIS, an archaeological inventory survey, archaeological preservation plan, cultural impact assessment, cultural resources preservation plan, and an ethnohistoric study that included the petition area. Although no cultural resources or practices have been identified within the petition area that would be adversely impacted by the proposed solar farm, this finding is limited to Parcel A and Parcel B of the petition area. Because You addressed the archaeological issues, but you didn't, the stipulation didn't address the kapa'akai or the traditional customary practices.
Right, so just to be clear, when you're talking about parcel A and parcel B of the petition area, you're talking about the phase one solar farm site.
Right.
Right, and then, of course, before you issued your decision in 2020 for the phase two solar farm site, you had made findings that included the kapa'akai analysis.
So my only point is I just would like that finding to be limited just to these two parcels and not to the entire project, the entire petition area.
So as you notice, I just turned to look at my client who gave me the thumbs up, but I would say, of course, because we have to do a not we, but my client has to do a cultural impact assessment as part of the EIS for the motion to amend. So,
right. So yes, you and I are on the same.
No
wave.
problem.
Okay, I just wanted it to be very clear. So yeah, because you've done a lot of really good work as it is already, and you assessed it specifically in relationship to the solar project. So I just wanted to make sure that in the future, if somebody else is picking up this order, they know that that finding is limited only to those two areas.
That would be fine.
Thank you very much.
Can I ask a question, Mr. Chair?
Please go ahead, Commissioner Ohigashi.
I just want to be clear. Are we talking, we're always talking about phase one, phase two, parcel A and B, phase A and B. So what my question is for the purposes of the record, can we settle on one description or one firm description that will stick with that type of motion? I just wanted to be sure.
So your point is very much well taken. The current motion that's in front of you has to do with the phase one solar project or the phase one project or phase one solar. Now, as long as the findings of fact clearly reflect what's meant by the phase one solar project, which is described not only in our motion, but also in our proposed findings and conclusions that we filed back in February, that's what I understand your conditions will be applicable to.
Yeah, I mean, I used the language in the motion. It says parcel A and parcel B, which is separate and a part of phase
You are
A and
correct.
phase B. So I recognize it's kind of confusing, although I've tried to maintain the way that you have identified these properties.
And you're spot on. And I also do point to perhaps to address Commissioner Ogashi's concern. But if you look at the amended stipulation that we filed, it says that the approximately 387 acre portion of the petition area identified as the quote phase one site, close quote, comprised of parcel A, consisting of approximately 151 acres, and parcel B consisting of approximately 236 acres, may be used as a solar farm, blah, blah, blah. Okay, but I mean, we're very, very clear that that's the areas that we're talking about. Does that address the concern you raised, Commissioner?
Yes, I just want to make sure that we're all talking about the same.
I appreciate that.
Thank you, Commissioner Ohigashi. Commissioner Chang, have your questions been answered?
Yes, I have them.
Okay. Any further questions? Any final rebuttal, Ms. Lynn?
This is Commissioner Cabral. I have a
Commissioner Cabral.
Yeah, thank you, Chair. And okay, same thing with the clarification. I bring my maps, remember? So you really have your interim solar phase one and phase two are located in landmass phase A and landmass phase B.
No, Commissioner Cabral. And I see that you're looking at the PowerPoint presentation, which is Exhibit 47. Would it be acceptable if Ms. Thone brings that up? There's a few different maps, but that way we can make sure that there's no confusion, Chair.
Please go ahead.
Okay, so I think
And
Yeah.
this is exhibit, again,
This is
47.
47, and I believe it's slide 5.
Thank you.
Well, at least on the PDF. So what you see here, you see how the master plan development is shown in those multicolors. So you have phase A in yellow, phase B is north of that, and phase C. Exactly. So I won't continue because you can see the colors and you can see the progress. And to the left of the PowerPoint slide, you see the approximate timeframes for vertical construction. Again, this is very estimated because we have yet to do the real nitty-gritty work on the master plan. But to come directly to your question, Commissioner Cabral, the solar farm that we're talking about today is up in the areas that Ms. Thone is moving the hand around on. So that's the phase, what we call the phase 1 solar farm, or the phase 1 site. And you can see how that phase 1 site is broken up into 2 different pieces. There's the solar 2044 parcel A, and again, and then there's the solar 2054 parcel B. Again, why did we break up AES's solar farm site into 2 pieces? We did that so that as the KS master plan development progresses up to the north, AES has to get out of there, out of parcel A, fully decommissioned by the end of 2044, so it doesn't impede progress of the master plan. And similarly, the parcel B solar farm will need to be removed no later than 2054 for that same reason, so that it doesn't impede the ongoing progress of the KS master plan. So phase A of the master plan, phase B of the master plan, they have absolutely no impact whatsoever on the solar farm that we're here to talk about today.
Okay, so they're located, the ones we're talking about are located in phase C and phase D of your color chart here.
Correct, and you can see there's a wee bit of it in phase E as well.
Okay, gotcha. Okay, thank you.
Thank you for asking. I know, again, between the letters and the phasing and stuff, it is.
Yeah, it is
challenging.
Yeah, thank you.
Okay, Commissioner Ohigashi.
Would the petitioner be amenable to a condition asking that they file a motion to amend the boundary amendment prior to 2030, when the infrastructure should be completed by?
So the condition would simply say, file that motion to amend before the December 31st, 2030 infrastructure deadline?
Yes.
I would have to confer with my client. I will just, let me stop there. I'll have to confer with my client, but I think if I can have your indulgence to do that, I think this will be a very quick discussion.
Go ahead.
Yeah, my solution.
For purposes of efficiency, I'm not asking us that we go into recess. I'm just asking that we just hang tight for a moment.
Sure, the mics are hot.
Ms. Lim?
Thank you. Thanks for that indulgence. So my client confirmed what went through my mind when I heard Commissioner Ohigashi, which is that condition would be fine.
Okay.
I'm not trying to hide anything. I'm just trying to say that it's a commitment that you're bringing it back to the commission. And the only date I can see is sometime before the 2030 deadline, which probably you have to do anyway.
That's correct. To meet that 2030 deadline, we're going to have to be back before you anyway. But if you want to articulate it in a condition, my client confirms we have no objection to that.
Commissioner Ohigashi, are you proposing an to be numbered condition?
Not at this point, I'm thinking about it.
Okay, commissioners, any further questions for Ms. Lim? Any chance to rebut? Are you done, Ms. Lim?
I am, Chair.
Okay.
Yeah, if there are questions, but I think I've taken a lot of time and energy from this commission already.
With that said, the commission will now conduct formal deliberations on whether to grant or deny the motion for modification. For the parties and for the public, I note that during the commission's deliberation, I will not entertain any additional input from the parties or the public unless those entities or individuals are specifically requested to do so by me as the chair. And if called upon, any comments will be limited to the particular question at hand. Commissioners, let me confirm orally with each of you that you have reviewed the record and are prepared to deliberate on today's docket. After I call your name, please signify with either an aye or an nay that you are prepared to deliberate on this matter. Commissioner Cabral.
Aye.
Commissioner Chang.
Aye.
Commissioner Giovanni.
Aye.
Commissioner Kamakea Ohelo.
Aye.
Commissioner Ohigashi.
Aye.
Commissioner Okuda.
Aye.
Commissioner Wong.
Aye.
Chair is also prepared to deliberate on this matter. Commissioners, the chair will entertain a motion that the LUC grants or denies the petitioner's motion for modification, time extension, and release and modification of conditions of the order granting the motion for an order amending the findings of fact, conclusions of law, and decision in order issued by this commission on February 11th, 2020. The motion should state the reasons for acceptance or non-acceptance of the motion and the conditions that will apply. Commissioners, what is your pleasure?
Giovanni,
Commissioner Giovanni,
I'd like to make a motion, Chair.
please proceed.
I move that we approve or grant the motion to amend, subject to conditions, and that those conditions include all of those which are in the second stipulated proposed conditions of approval that we received, which are dated May 24th, 2022, subject to an amendment of one of the conditions and inclusion of additional conditions as follows. Condition number 9 is the WAIAWA Master Plan Infrastructure deadline. I'm going to read the whole thing because I want it in the record. Petitioner shall complete construction of the backbone infrastructure for the proposed WAIAWA Master Plan Phase A, consisting of the primary roadways and access points, internal roadways, on and off site water and electrical system improvements, and storm water drainage and utility system improvements by December 31, 2030. The additional is the amendment to that condition, which will state, in addition, the petitioner shall complete construction of similar backbone infrastructure for the proposed WAIAWA Master Plan Phase B by December 31st, 2038. That's the end of the amendment. I'd like to add to the conditions, the one that was described by Commissioner Chang regarding the cultural impact assessment. I don't remember the exact wording, and so I will defer to Commissioner Chang to make that clear. I would be happy to provide supporting reasoning for my motion at the appropriate time.
Commissioner Giovanni, before I ask Commissioner Chang for her wording, which is going to be incorporated into your motion, was that the entirety of your motion? Were you also going to try and incorporate Commissioner Ohigashi's concern?
I will defer to Commissioner Ogashi if he wants to make a friendly amendment.
Okay, so before I ask for a second, would you read into the record, Commissioner Chang, the proposed language that Commissioner Giovanni is including in his motion?
Yes, Mr. Chair. I guess it would be, or whatever the next condition, numbered condition, it will read underscore protection and preservation of Native Hawaiian traditional customary practices, paren, Articles 12, Section 7, close paren, and end of the underscore. And the paragraph reads, petitioner has conducted an archaeological inventory survey, comma, an archaeological preservation plan, comma, cultural impact assessment, comma, cultural resources preservation plan, comma, an ethno-historic study that included the petition area. Although no cultural resources or practices have been identified within the petition area that would be adversely impacted by the proposed solar farm, this finding is limited to parcel A and parcel B of the petition area, period.
Mr. Chair, I second the motion.
Okay. A motion has,
When Commissioner Chang referred to parcel A and B, that was of the phase 1 solar area, not of the total petition area, not the master plan A and B, correct?
Yeah. So, okay, a motion has been made as articulated by Commissioner Giovanni with the assistance of Commissioner Chang. Commissioner Ohigashi has seconded the motion. I will ask the movant and the seconder to speak to the motion, and then we'll go into broader deliberation.
I'm in favor of the solar farm being an interim use as proposed by the petitioner. I think it's a very important project, and it's being conducted by a reputable and proven developer in Hawaii. And I think that they have adequately satisfied my concerns as expressed by the office of, also by the office of State Office of Development and Planning and Sustainable Development regarding the issues raised in the civil deed issue. So I think it's an important project. I want to move it forward, and hopefully it will put a shovel in the ground pretty soon and it'll be up and running. So great project. I have added the second, the amended condition to condition number 9, consistent with what was proposed and is on the record here, that the backbone infrastructure is expected to be done by 2038. So all I'm doing is reflecting that. It's an important consideration for us. And then I support the condition added by Commissioner Chang because it's appropriate and it was missing. So I encourage my fellow commissioners to support this important project.
Thank you, Vice Chair Giovanni, First Vice Chair Giovanni. Commissioner Ohigashi, do you wish to speak to your second?
Yes, Mr. Chair. I find that the solar projects that has been already approved, that they were interim and temporary in nature. What supports that type of finding even more would be that they are required to be decommissioned and the land reverted back to its original state. I do not view that as a commencement of any type of infrastructure that has been relating to the original DBA. And therefore, I think that given this temporary interim use, that I can support the motion. I did contemplate, and after this second, I would like to contemplate a motion that we add a condition to require the petitioner to file a motion to amend the DBA prior to the deadline period for the infrastructure, for the phase A infrastructure, which is December 31st 2030, December 31st, 2030. And the reason for that motion that I intend to make would be so that we realize there is a commitment to the development of housing, and that the commission has in its grasp a specific condition to say that, yeah, you got to do this before that date. Otherwise, there may be significant repercussions. Finally, and I'm taking this out of order because I don't have my notes in front of me, but finally, the reason why I'm supporting the motion is that basically solar projects are allowed on agricultural land. So given the fact that this is urban land does not necessarily negate, or given the fact that this is a project that's allowable on agricultural land, that even if for some reason there is a reversion, the solar project would still go forward because it is permitted on agricultural use. And that's my reasoning. And with that, Mr. Chair, if you would, I would like to make a motion that to amend and add the condition that the petitioner file a motion to amend the boundary amendment prior to December 31st, 2030.
To be appropriately numbered. Okay, so this is where we're right at the edges of my parliamentary procedure. Normally, it would be somebody who's not the movant or the seconder who makes such a motion, but I don't think it's material. Does the movant object to the addition of that?
Movant welcomes it.
Okay. And clearly, Commissioner Ohigashi would agree with amending the motion. So we have an amended motion in front of us with the stipulated conditions and I believe 3 additional conditions as have been articulated. We are in discussion. Commissioners.
Mr. Chair, can
Commissioner Chang.
I'm going to speak in favor of the motion, but I'd like to see if I can address specifically some of the points that were raised by Commissioner Ohigashi and probably make another friendly amendment. This is going to be I'd like to propose some changes to the stipulated proposed conditions, paragraph 7. So what I'm proposing is that the paragraph would read.
Hold on one moment, Commissioner Chang. I'm going to ask the petitioner's co-counsel to throw this up so that we can all see it easily.
Good idea.
Ms. Thone, are you able to do that? Thank you.
Okay. So what I'm proposing is paragraph 7, after the word interim, insert and temporary. Interim and temporary use of the petition area. Likewise, the next one, the interim, insert temporary use of the approximately 387 acre portion of the petition area as shown in petitioner's revised master plan and schedule for development filed October 7th shall be limited to a utility scale solar energy development or solar farm. Insert the proposed solar farm and previously approved solar farm is not, no, okay, sorry. Start off the sentence with, however, the proposed solar farm and previously approved solar farm is not in accordance. Wait, I actually had it written down. Is not, quote, substantial commencement of use of the land in accordance with such representations, close quote. And then the remaining paragraph. so that it's very clear that the solar farm is not to be considered substantial commencement of the representations. I think it's substantial commencement, but I think if you read and I'd like to also insert after that sentence, HRS 205-4, paragraph G, because it specifically says substantial commencement of use of the land in accordance with such representations. And the representations by Gentry at the time it was approved was for a housing project, not a solar farm. And the solar farm, as described by Commissioner Ohigashi, is a temporary use. So I think that kind of clarifies, and that addresses, in my mind, some of the language or thoughts that were provided by Mr. Yee.
Okay, so Commissioner Chang, I'm going to try and restate back what you have proposed. Condition 7 would now read as follows. Interim and temporary use of the petition area. And that phrase is underscored, period. The interim and temporary use of the approximately 387, and then that sentence continues into the word farm. Following that, there is an insertion of a new sentence that says, however, this, and you'll have to give me the phrase, this shall not.
No, I have this, the proposed solar farm and previously approved solar farm, because there's two farms, Parcel A and Parcel B, Parcel A and Parcel Phase 1, Phase 2 of two solar farms is shall not be considered some quote substantial commencement of use of the land. In accordance with such representations, close quote.
And then a citation to
HRS 205-4, paragraph G.
Okay, I think we're clear with the amendments, the first and second sentence. Can you restate for the record that third sentence?
Okay, I'm going to try again. It says, however, the proposed solar farm and previously approved solar farm is not, quote, substantial commencement of use of the land in accordance with such representations, close quote, HRS 205-4, paragraph G, period.
I'm going to ask the move on to Commissioner Giovanni and the seconder, Commissioner Ohigashi, whether they are fine with the proposed amendment to the main motion.
Commissioner Giovanni accepts the friendly amendment from Commissioner Chang.
Commissioner Ohigashi.
I guess so, yes.
If you've got better language, I'm open. I think we're all trying to get to the intent.
Commissioner Ohigashi, is that a yes?
Yes.
Okay. We are in discussion on the amended motion to approve. Commissioners, Commissioner Wong,
Thank
I
you,
believe
Chair.
that's your arm.
Yes, that is my arm. First, can we take the wording down?
Yes, thank you. Thank you, Ms. Thong.
Do we need, can I ask, or can you ask the petitioner and whoever approved, support the STIP, the second STIP, if they're okay with that Commissioner Chang's statement?
Solely Commissioner Chang's statement?
Yes, or even Commissioner Ohigashi's statement. I think.
Sorry.
Commissioner Ohigashi's statement was okay, was just Commissioner Chang's.
Okay, I'm going to ask each of the parties one by one whether there's any concern with the proposed and accepted amendment to the motion made by Commissioner Chang just now, beginning with the petitioner.
Thank you, Chair and Commissioners. So when I hear it, a couple of thoughts went through my mind, which is, this sounds like a finding and not a condition. So it seems sort of odd to put it into a condition. And then it's a wee bit confusing what representations we're referring to. And so I know I have to limit my comments to just responding to the question, but I'll just get in there. I think that the proposed findings that Mr. Yee articulated possibly achieve the goal that I believe you're trying to achieve without maybe making some confusing language in conditions.
Is that the totality of your comments in response to the question, Ms. Lim?
It is. Thank you.
Mr. Pang, DPP.
Thank you, Mr. Chair. With respect to the phrase and language, the city did not have any objection. However, we did have that same knee-jerk reaction that the petitioner had, that perhaps the reference to substantial commencement should be in a finding rather than a condition. Just a suggestion.
Thank you, Mr. Pang. Mr. Yee.
PSD has no objection to Commissioner Pang's proposal, nor do we have an objection to the insertion of a finding.
Mr. Wong.
Yeah, Chair. The statement that Commissioner Chang brought up, I do agree with. I'm just also have that concern if it's a finding or is it part of the condition. That's all I wanted to know. I don't know if we should. Can I ask the RAG if that's what his thoughts are on this?
Please.
Wherever he is. Oh, there.
Mr. Morris. Oh, you are muted, Mr. Morris.
I think a condition can be imposed with a certain understanding, as Commissioner Chang has articulated. But I don't think it's defective for not calling it a finding, or it could be treated as a finding. But I think it's really an understanding of the LUC in connection with the condition they're imposing.
Commissioner Wong.
Okay, that's good enough for me. I can live with it. Thank you.
Okay. Commissioners, we are in deliberation in our motion to approve as amended.
Chair.
I couldn't. Commissioner Wong.
I'll support the motion and all the friendly amendments. Well, yeah. So I just wanted to say that, solar farm is very important to us, as we all know, and also affordable housing. Like, for example, I want to make sure that my kids and grandkids have affordable housing. Hopefully I have grandkids. But I just wanted to say for the record that I hope that Kamehameha schools make sure that we do have affordable housing in the future for our kids. That's all. Thank you.
Commissioners, thank you, Commissioner Wong. Commissioners, we are in deliberation.
Chair, it's Gary Okuda, if I may.
Please proceed.
To follow up one of my dear friend Commissioner's statements, so I can disagree with him slightly. As I mentioned at the earlier hearing, I don't believe that the duty of Kamehameha School / Bishop Estate is to provide affordable housing. It would be nice if they did so, but that's not the duty of their trustees. But be that as it may, we do have a concern about providing housing. And that's the reason, and let me just preface this by stating, I'm speaking in favor of the motion, but I'd like to give some additional reasons. We are in favor of housing, no question about it. And I believe this commission is in favor of housing which is affordable, which is directed to the extent possible by law for residents and citizens of the state of Hawaii. Of course, not excluding anybody who has a constitutional right to move to Hawaii. And we take seriously the admonition and warning of the Hawaii Supreme Court about why we don't want to have property which is allowed to be used for speculation, where we grant entitlements and development doesn't take place. And I think it's worth repeating the admonition or the warning from the Hawaii Supreme Court in the Bridge Ainalea case. And, I'm reading from 339 Pacific 3rd. Case appears at 685. That's the unofficial reporter, but this is at pages 709 of the Pacific 3rd to 710. And the reason why you have this, this restriction or warning by the Hawaii Supreme Court, and if you can give me a second to get back to my page here, is basically a warning by the court that as a matter of public policy, we don't want to have land speculation, which seems to take place more easily if property is allowed to stand here with entitlements and no development takes place, because that just allows the potential for the properties to be flipped, to be resold, and the promised housing, especially the promised affordable housing, never occurs. And as you know, what this commission has done, at least the present members of the commission, is we have had no problem reverting property back to its prior designation, where the evidence has shown the landowner has not shown any real movement towards providing housing or fulfilling its promises and representations made to the commission. So we have no problem to revert the property to basically comply with this direction of the Hawaii Supreme Court and the direction of the legislature not to have speculation. But I would like to say this, even though, and this is just my personal view and personal conclusion from the record and the evidence presented, even though this has been a long delayed development, as the chair pointed out, dating back to when people were almost in adolescence, this is not the same factual or legal situation that we've had in our other cases. I am not advocating or saying that the Kamehameha schools or the Bishop estate are to be treated any differently like anybody else. Everyone who appears in front of this commission is subject to the same scrutiny, the same requirement. They follow all the requirements of the law. But without getting into the entire record of the case, I just like to state for the evidentiary or the record in the event that this case is subject to further review. I incorporate by reference the history of the Bishop Estate Kamehameha schools, which was set forth in the en banc, meaning the entire panel of the Ninth Circuit Court of Appeals in the case Doe versus Kamehameha Schools, Bernice Pawahi Bishop Estate, which is found at 470 Fed 3rd 827, a 2006 Ninth Circuit Court case. I don't have to repeat the history of Hawaii or the history of the Kamehameha schools, which the Ninth Circuit Court explained in great detail with very clear citation to legal precedent and historic record. But the Kamehameha schools, with its present mission, affirmed by the Ninth Circuit Court, a case which was not subject to a petition for writ of certiorari to the U.S. Supreme Court. Those facts, I believe, have to be taken into account. And because of that, I'm less worried or scared that we are dealing with a land speculator here. And frankly, if I could be a little bit facetious about it, but it's not really that facetious, if one of the elite trusts can make money from land speculation to educate Native students, hey, that's okay with me. So for those reasons, I will be supporting the motion.
Thank you, Commissioner Okuda. Commissioners, we are in deliberation.
Mr. Chair.
Commissioner Chang.
Thank you for the opportunity. You know, this has not been easy, and I realize that. I think petitioners came in thinking that this was just a motion to amend and addressing the solar farm. But I think as you've heard from all the other commissioners, there's a lot more at stake than just taking this in isolation. But I am extremely optimistic. I think the Kamehameha schools, their vision, I do believe that they are going to do community outreach. I know the leadership that's with this team, and I am extremely confident that they're going to ensure that that happens. I'm also confident that they will make sure that there's protection and preservation of traditional customary practices, not only for today, but for the future generations. So that optimism is what makes this really hard, is because, you know, Commissioner Okuda says, you know, we have to treat everybody the same, but there is an expectation of Kamehameha schools, and I don't, you know, please don't take offense if, you know, anything that I've said has been taken the wrong way. The spirit upon which, for me, it was to ensure that one, we are, oh, thank you, sorry, that you know, we have the ability, or that we are treating all the petitions that come before us from a policy standpoint, and from, as Commissioner Okuda read, you know, from Burjaina Leah, treating them the same. However, I think there is, based upon the representations that have been made by those representatives of Kamehameha schools, again, is what gives me optimism that while we've been pushing you hard, I think you will come through. I am confident that you will bring, you will do good. You will make us proud that you are going to build the housing that you're representing. And for those reasons, I'm supporting this temporary use, but I'm also anticipating that you've heard us and that you'll be moving in a timely fashion, the environmental review process, the community engagement process. And I probably won't be on the commission at that time, but looking forward to reading about it. And I am hoping the best for this project and the team that you have. So thank you very much, Mr. Chair.
Thank you, Commissioner Chang. Commissioners, we are in deliberation. The way the camera is, I cannot see except only 3 of the commissioners.
No.
Squeak it.
Commissioner, please proceed.
I'd like to mahalo the petitioners today. And, you know, I know this is my first hearing involved on this matter. However, I've received the entire record in this matter and I'm ready to proceed. And with that, I just want to say that I'm in support. Mahalo nui.
Thank you, Commissioner. Commissioner Cabral?
Yes, I will say a few words. I want to thank my fellow commissioners for the work they've done to try and help move this along, because that I think everyone's in favor of saving our environment and having energy efficient devices to help us do so. So I appreciate that, and we've had our concerns that I think the motion has been able to address. And so as much as I'm okay with this, and I understand that 6 or 7 votes will move this forward, I have lately become very outspoken about housing, not affordable housing. Not that I'm not for affordable housing, but affordable housing. And I manage HUD affordable housing projects, so I understand what that means in terms of what that does to our community and how that brings outsiders in to fill up our federally subsidized housing projects. So that's a separate entity. I am in very, very, very much in favor of more houses, more sticks on the ground, more housing. And my dream would be that instead of talking about photovoltaic often in land with nothing else around it, I would very much like to have us making a motion that we'd have photovoltaic on the 11,000 houses that would be going up very rapidly. So for that reason, I'm going to just go on the record of voting against it because I'm very much in favor of housing, but spiritually I'm with you. Thank you.
Thank you, Commissioner Cabral. Anything further from my fellow commissioners?
Giovanni.
Commissioner Giovanni.
Yeah, I want to just thank my fellow commissioners for the positions that they've expressed, both in favor and not in favor of the motion. I understand them all. I want to add a little more commentary, if I may. This is not a simple hearing about a solar project. All the consternation, all the frustration, all the dialogue that was shared between the parties and the commission was about the frustration because we haven't seen a house in 35 years since this original property was deemed and approved as such. So that's what it's about to us. So it's kind of like a warning. If this was just simple, we want to put a solar project on agricultural land, pretty much a slam dunk because the project is so viable. I am, as my fellow commissioners have expressed, in great admiration of the greater vision and mission of Kamehameha Schools. Tremendous supporter. However, I do not share Commissioner Chang's optimism. In fact, I'm an absolute pessimist when it comes to this specific piece of property and whether or not you'll ever build a house on it. And I challenge you to prove me wrong. Please prove me wrong. Thank you. Nothing further.
Thank you, Commissioner. Anything further? If not, I will share my remarks. I have a lot on my mind right now, today at this hearing. We recently lost a former member of this commission, Commissioner Colette Machado, who had a remarkable career in serving the Hawaiian people in Hawaii. And one of her first areas of service, as I think like barely out of her teens, was on the State Land Use Commission. So I kind of have her lead and example in my mind, and she never shirked or got scared from challenging any entity or party about what she thought was best. So, you know, as I thoughtfully consider all the fellow remarks from my fellow commissioners and their good presentations from the petitioner and the parties, I come back to a question I've raised before during these hearings. Why are we here? Why is this so hard for what should be so easy? There were some, and I will call from this point of 2022, looking backwards, some really bad decisions made by former trustees to hand this over, from former developer to propose something that was just not a great idea, from fellow former commissioners for approving it, from the city for then going along with it and agreeing to the zoning for it. So we are unfortunately stuck in this particular position. We don't get to choose to work from a blank slate at this point. We have to move from where we are. That means a lot of things are not optimal. I don't even actually share this sort of great excitement over the proposed solar project. And let me be really clear as to why. It's not that we don't need more solar energy in Hawaii, we do. But when the push for renewables in Hawaii started very heavily under the administration of Governor Lingle, one of the things that she pointed out was like, hey, we're sending off $10–12 billion a year to foreign companies for fuel. Are we benefiting from that? We should be generating this energy ourselves. And now we're like generating a lot of this energy ourselves, but all that money is still going offshore. The amount of wealth that we're exporting when we turn to these outside companies, no matter how good and critical they may be, is significant. And it doesn't necessarily, I think, get to the larger vision of not just a renewable, but a just Hawaii that we want. And so we are where we are. This is the best we can do going forward. I am probably caught somewhere between Commissioner Chang's optimism and Commissioner Giovanni's pessimism about what might happen next. I urge and implore Kamehameha Schools to clearly and deeply ask this land what it wants, what its own people, the Hawaiian people, need and want and can offer to this land, and what the neighboring community in all of Hawaii can benefit from this land as they pursue a master plan. And I really look forward to one that does come together, that is really representation of all these stakeholders in that order, their needs and desires. The one comfort I have is, and this will be the conclusion of my remarks, I had the opportunity of working, before I worked for Kamehameha Schools, for a Kamehameha Schools lessee, what is now known as the WAIAWA Foundation on the North Shore of Kauai. And when they first managed to beg a lease out of Kamehameha Schools because they wanted to restore an Ahupua and restore Taro, and it was at the time when Kamehameha Schools looked at them askance and said, well, no, that's not what we do with our land. What we do with our land is make money to educate kids in classrooms. And these folks on Kauai said, no, we want this land to educate kids here. One of the things when they finally got their lease, they asked the trustees for a simple machinery to clear land. And trustees, the schools would not give this, at that time, small, struggling nonprofit or actually a for-profit at that time, any money for basic equipment. But reflecting a decade later, as they started their land use master plan, Kavika Sproat said, thank God we didn't get it, because we didn't know this land the way we do now. And if we had just started in at that point, we wouldn't have done what's best for this property. So I'm hoping that all these missteps, all these mistakes, all these bad decisions to this point might allow us this window to go forward in a way that really honors this place, honors the institution and its beneficiaries, and honors all of Hawaii. I have nothing further. If there's nothing further from my fellow commissioners, I'd ask Mr. Ordenker to please poll the commission.
Thank you, Mr. Chair. I'll do my best to be concise on this. The motion is to approve or grant the motion to amend, subject to conditions, including those contained in the proposed stipulation, with amendments to condition 9 with regard to phase B, and add a condition using Commissioner Chang's suggested language with regard to protecting Native Hawaiian traditional practices in condition 9, and an amendment with condition 7 with regard to substantial commencement, as well as Commissioner Ohigashi's motion that a petition or motion to amend be filed prior to 2030. Commissioner Giovanni.
Aye.
Commissioner Ohigashi. Commissioner Chan,
Aye.
Commissioner Kamakea, hello.
Aye.
Commissioner Okuda,
Yes.
Commissioner Wong,
Aye.
Commissioner Cabral,
No.
Commissioner Scheuer.
Chair votes aye.
Commissioner Axon is excused. Chair, the motion passes with 8 affirmative votes.
Thank you very much. Congratulations to the petitioner. Thanks to the parties. Yes.
Chair. I think the number is wrong. It's supposed to be 7 and 1. Commissioner Cabral voted no.
Oh, I'm sorry, I
Thank you for the
didn't hear
correction.
that. I thought she said yes.
No, she said no.
Thank you for the correction.
Please restate the final tally.
The final tally is 7 ayes and 1 no.
Thank you.
I'd also like to just applaud our chair, Schroyer, for his last comments, which might be his last. So thank you for the great job you've done.
Thank you. Thanks so much to the petitioner and to OPSD and the county for your participation in these proceedings. It is 1:36. We have a little remaining business to do. Before we close, Ms. Lim, you wish to say something?
Well, I want to thank you, Chair, and your fellow commissioners. And then for clarification, will we be returning for a hearing on approval of an adoption of the final
That is
order?
correct, yeah, and that should be sometime in the month of June.
Okay, thank you. Thank you.
Anything further on this docket? It's 1:36. Let's reconvene in 9 minutes at 1:45 to take up the final 2 matters on our agenda, though I think we're going to be deferring the matter on the election of officers and simply moving on the matter related to LUC employment. Recess till 1:45. Okay, I can see 4 of the commissioners.
We're all here. Even Nancy's here.
She was very good yesterday.
Yeah, she was very good.
Even Arnold is here.
Okay, it is 1:46. We are back on the record. Recording has started again. Our next agenda item was discussion and action on election of LUC officers. At the last meeting, commissioners appointed permitted interaction group of Commissioners Wong, Axon, and myself. We haven't had a chance to meet. Is there any public testimony that's been submitted on this, Ms. Quinones?
No, Chair, no public testimony was received.
Okay, commissioners, with your permission, I'd like to defer this till our next meeting. Any objection?
Well, Mr. Chair, Ms. Lim may have something to say.
No.
Put her on the spot right
No, let me out of here is what she says.
He's asking if anybody for election of officers.
So Chair, can we tie that date down? I know that our executive director gave us the calendar, but I think it's June 23rd. It's the only meeting I see before everybody, the 3 of you go off.
Commissioner,
That's
Mr.
correct. June
Ordenter?
23rd is the next scheduled date for a meeting.
So this will be agendized to June 23rd.
Yes, that is correct. May I suggest that since we're going to have a June 23rd meeting as well, that we defer the personnel matter as well.
Notify Jennifer.
Yeah, Chair, I'm still not finished with all the reviews yet. So if you don't mind, we can push that off too.
Okay, well, so let's just, for a clear record, with the understanding it would be agendized for the 23rd. Is there any objection to deferring the agenda item regarding election of LUC officers?
No.
Seeing no objection, it's deferred. Now, the second item, it's been suggested that we also defer to the meeting on the 23rd. executive session regarding personnel matters. Commissioner Wong, was this what you wished to speak to when we got back into session?
The only other item that I wanted to bring up for the next meeting, if possible, is the one that is going in front of the AG, the appeals thingy. If we can,
Not Rodenhurst, the
Rose Hill.
Rose Hill appeal.
Yeah.
We can agendize that for the next meeting as well.
Okay. I would also seek to agendize for the next meeting, though it might be, we might need an earlier meeting to meet the appeal deadlines on the recent ICA decision regarding an overturning of a circuit court decision that overturned our decision regarding a special use permit on the island of Maui.
I have not received any we haven't officially received that through the AG's office, to be honest with you. I don't know what their intentions are with that.
But it's been published.
Yep.
What case is that?
Let me get you the exact citation. Sorry.
Schools up to something?
It's not a case that we decided.
Sorry, just so you know, I can't really hear who's talking.
You're boarded.
Chair, it's
Yes.
Moana Foundation
Yes,
versus Land Use Commission.
thank you.
I'd have to go into it.
Oh, okay, sorry. I just don't remember.
It's it's an ICA decision filed May 23rd, 2022 at 8:40 a.m. CAAP-17-0000173 and same numbers 181.
What's it about?
Moana Foundation appellant appellee versus LUC State of Hawaii and Pu'unua Homeowners Association and Ross Scott.
Campgrounds on Lahaina.
Yeah.
And
It's before me.
Yeah, is this commission?
the circuit court.
I would caution that this matter wasn't agendized.
Yeah, so
Yeah.
I'll just noting that we'll place this on the next agenda for discussion.
I do have one announcement to make.
Okay.
We just received notice during this hearing that the DW Ainalea case, well, let me back up. If you recall, Bridge Ainalea was heard and done. And then there was another party to the whole Ainalea debacle by the name of DW Ainalea. And they had filed a lawsuit against the state, pretty much mirroring the Bridge Ainalea lawsuit. The appellate division at the Attorney General's office had filed a motion for summary judgment with the court, the federal courts, and that motion was granted today. So that's good news. If anybody wants any more information on that, they can contact me directly and I can provide you with what I know.
And Mr. Ordenker, your caution about the commissioners needing to keep their calendar open for reserved dates includes those dates in June?
Well, we have the 22nd and 23rd. The 22nd, however, is the Native Hawaiian Law Training Course, which will require at least one of our commissioners to attend, which is why we moved our hearing for June 23rd. If there is a need, we do have June 8th and 9th, I will not be available for those meetings, I don't believe, but they can still be held and Scott can serve as
So
executive.
June 8th and 9th are not released is what I'm asking.
I thought we released them actually, but if the commission feels it needs to meet on the Rose Hill petition before then we can do.
Commissioner Ohigashi?
The only problem is I have a doctor's appointment at 8, but it's by telephone, so.
Okay.
But anyway.
Is there any further business, commissioners, or any questions or comments, announcements? Commissioner Chang.
Yes, thank you. I guess this is for Dan. I mean, is there a way that the commission can get updated on appeals or cases that have either been appealed or when they're appealed?
I think Diane Erickson used to provide us update.
Yeah.
Finding out the day of the decision, or, I mean, we are the commissioners, and I think at a minimum, we should be provided some, whether it's by email but some notice when an appeal has been filed or when there's an update on the status of an existing.
Yeah, I will talk to our Attorney General, Deputy Attorney Generals about that.
Thank you. And I know it's not agendized, but due to the time concern, the Rose Hill appeal, because I never did get anything from Julie Chino. I'm sorry.
Neither,
Dan Morrison.
oh, you didn't? Okay, you were on the email string, but apparently that they're meeting.
I do want to caution us that we're not talking about an agendized item here.
Yeah, I know. It's just the only thing is it got moved to 2 o'clock. That's all.
Either Dan. So we are supposed to be there at 2 o'clock because is that correct? And then my next question is, if you say yes, we're supposed to be there.
I'm going to call Julie immediately after this, or Linda, and find out what's going on, because we haven't gotten confirmation that you're allowed to attend yet.
I think we need to wrap this up, given the failure to agendize this particular item. Is there anything further on our agenda, commissioners? Seeing none, thank you very much. I declare this meeting adjourned.
Thank you.